The last week I filed an application. My lord, is the school authority wanted to place the services of the teachers in the hand of a contractor. Being satisfied, your lordship state that particular NIT. Now, when I placed that order before the management, well, the principal was transferred to some other job, which is not her job. Now, they are contemplating to oust my service also. I filed an IM, my lord, if your lordship kindly take it at 2 p.m. Obliged.
Item number 39 and 40, my lord. I appear for the respondents 3, 4, and 5 in both the cases. We need some time to file our affidavit, my lord. A 2 weeks time may be granted. I have informed all the parties.
Wait for your turn.
My lord, it has been listed for orders because I have not filed the affidavit.
Let it reach.
My lord.
May it please your lordship. My lord, I may be allowed to call an IA in item number 28, lordship. I filed it, lordship, regarding infringement, lordship.
May I please the lordship, my lord, I beg to mention item number 8, my lord, on behalf of the health department. I have taken consent of the petitioner, my lord.
Wait for your turn, Bora.
Lordship, consent taken from the opposite party, Lordship. I beg to mention item number 24, Lordship. Here in this case, Lordship, assisting lawyer who engaged Mr. B.D. Goswami, he has, due to his mother's illness, Lordship, he is unable to come before the honorable court, Lordship. And we have already informed opposite party, Lordship.
Wait for your turn. You have not given your mention memo, isn't that?
No.
Those who have not given the mention memo, no need to mention. Wait for your turn.
Obliged.
Made privilege. Lordship, I beg to mention for listing in contaminated in next week, my lord. The
Why next week?
my lord,
Why next week?
my lord, the direction was given in the contempt case, in the main judgment, my lord. We reinstate the petition within a period of 15 days.
30.
Master.
May I please your lordship? Lordship, with regard to item number 48, Lordship, it is a contempt petition.
Mm.
Lordship, it has been listed in the orders, but no notice has been issued.
Just you wait for your turn.
May I please, Lordship? Lordship will remember that matter was posted on 21st of this month for hearing. And during course of hearing, it was noticed that there is some minor typological error in the constitution. Accordingly, Lordship directed me to file an IA for correction, and I have filed it. And matter is posted on 28th. So this IA may come up on 28th, Lordship.
Yes.
Lordship, and regarding item number 9, the arguing counsel, Mr. Jalaskar, has some personal difficulties.
Wait for your turn.
Lordship.
May I please your lordship? My lord, I beg to mention a writ petition for listing, my lord. My lord, the matter pertains to medical reimbursement. My lord, kindly give me any date after vacation.
Yeah, after vacation. I'm not giving a date after vacation.
I beg to mention item number 6, my lord. And this council has been suffering from fever, my lord. Matter will be taken up.
Wait for your turn.
May it please your lordship. Lordship, with the concern of the others, lordship, I beg to mention item number 42 would be upgraded, lordship. This is a
Why?
lordship, there is a, it is a, on the last occasion, lordship, they are to submit the complaints report, lordship. Today morning I have intimated. They need some orders from this honorable court, lordship, to comply this order.
Wait for your turn.
Lordship, matter will be taken up before lordship rises.
That I'll take up.
May it please your lordship, I beg to mention item number 29 and 31, lordship. Matter may be adjourned for the day only.
Why?
Huh?
Why?
My senior brother-in-law expired, that's why not. 29 and 31.
Who's your senior?
KDV
29 and?
31.
Okay. On request, Madam, we have a MSK Devi, then a council for the petition. List after the summer vacation.
May I please your lordship? I beg to mention for listing of an IA lordship. Can be list for list on Tuesday, lordship.
What is the IA about?
IA about the stay vacating and improvement lordship.
When did you file it?
On 17 lordship. 17/6 lordship.
Next week.
Lordship, I beg to pray for listing of a repetition for motion stays.
For
Motion stays.
motion stay?
Yes.
For motion?
Yes.
Yes.
Lordship, please may list on Monday.
No, 30.
Lordship, I have another similar matter.
Motion,
Yes,
that also,
yes, Lord.
30.
I'm blessed, Lordship.
Please, Lordship.
Yeah.
Lordship, item number 55. Lordship, it should have come for motion, Lordship. On the last date when the matter was called for, we came to know there was a small error in the cost title. So we are directed to correct it by hand in the course of the day.
Wait for your turn.
Of last.
Please, your lordship. I beg to mention for listing of a writ petition. It was, the notice was issued on January, 27 January.
After vacations,
My lord, maybe on Monday, my lord.
no, after vacation.
Notice was issued returnable 8 weeks, my lord. but-
Yes. After vacation.
Item 1 of daily list.
May I please, as your lordship? Lord, this matter relates to, my lord, the constitution of the governing body of a B.Ed college, my lord, namely the Patharkandi College of Education. My lord, our grievance is that these colleges are being, my lord, affiliated under the, my lord, Assam University Silchar. My lord may be pleased to find the affiliation, my lord. At page, my lord, 40. Page 40, my lord, these are the, my lord, committee quorum, and this was taken on the 5th August of 2004 at 2 p.m., my lord. The Vice Chancellor, Assam University, Silchar, welcome all the members. The committee then discussed the agenda items and took the following decision. Item number 1, confirmation of the minutes of the 23rd affiliation committee meeting held on so and so. My lord, may skip this part, and my lord, may be pleased to find that at page 42, my lord, that the AFC on 24/8/04/23, the committee perused the inspection commission report above colleges and resolved to accord the temporary affiliation from session 2003-4. And as per the report of the inspection committee, subject to fulfillment of all conditions of the NCT norms and University Act, statute, ordinance, and regulation, and renewal of the affiliation fee in the every year, the B.Ed colleges of the course of the following colleges. My lord, serial number 2 is the petitioner before my lordship, my lord. Now, my lord, what has happened? The NCT has also issued regulations for the purpose of constitution of the governing bodies, my lord. My lord, may kindly turn to page 55 of my writ petition, my lord.
Yes.
My lord, page 55, I am drawing my lordship's attention to clause 7 is the managing committee, my lord. The institution shall have a managing committee constituted as per the rules, if any, of the affiliating university concerned state government. In the absence of such rule, the institution shall constitute the managing committee on its own. The committee shall comprise as representative of the sponsoring society, trust, educationists, and teachers, educators, representative of the affiliating university, and of the staff. Now, my lord, though this rule is governing, my lordship has found that the committee, as per the rules, if any of the affiliating university concerned state government. Now, my lord, when this writ petition was moved, my lord, initially before this honorable court, this honorable court, my lord, requested the, my lord, learned council appearing the Assam University Silchar that what are the rules regulating the conditions for constitution of the governing bodies. My lord, then they have come up with a notification of office memorandum dated 9th of July 2009. My lord, this is the same rule, my lord. This is rule called the Assam Non-Government College Management Rules 2001. They are following for the purpose of constitution of the governing bodies of these categories of B.Ed colleges, my lord. So, my lord, our case is that while the fresh committee has been constituted, my lord, this rule has not been followed. And they have, my lord, their own, they have constituted.
Which rule?
My lord, the Assam Non-Government College Management Rules 2001. My lord, may be pleased to find at page 437 of this manual, my lord.
Education manual.
Yes, my lord, no, my lord, that one, yes, my lord. Page 437, my lord. Page 437, and the rule 3 is the, my lord, composition of the governing bodies.
Yes.
My lord, as per this rule, my lord, the committee is required to be constituted, one president, one secretary, the vice principal, ex officio, 2 members to be nominated by the affiliating university concerned, and 3 guardians of the student studying in the colleges. So, my lord, this is the quorum as per the rule. But, my lord, what they have done, they have not followed this rule, which is, my lord, apparent from the instruction, my lord, which had been received, and the communications and the advertisement which they have made. In the, my lord, we have only come to know that the committee has been constituted, my lord, when this advertisement has been issued at, my lord, page 56, annexure 7. Lord, this is an advertisement issued by an authority or by a committee, my lord, which has not been constituted in accordance with the, my lord, law. My lord, as this case has come up after a long break, my lord, nearly we have filed it on 21, my lord. For certain reasons, it was not listed, my lord, and also it was, my lord, out of my track, my lord. So as this matter has come up of late, my lord, may I pray, my lord, may be pleased to issue notice at this moment, and I am not praying in an interim, in a belated stage, my lord. Let my friend appearing on behalf of the, my lord, Assam University, and there are private respondents are also there, my lord, at respondent number 6, 5 and 6, my lord. They are also required to be heard, my lord.
KL, you are appearing?
I'm for the Assam University.
But Mr. A.K. Bayan, Mr. Who appears for elementary?
University.
I'm for NCT.
Elementary education.
I'm appearing to no one.
D. Kaushik. The standing council appears, elementary education appears for respond number 1. And state SCRT.
But SCRT, they have a council, my lord.
There is a standing council.
Mr. I.
As for-
Learn standing council. NCT appears for respond number 3.
My lord.
And Mr. SCKL and it's standing council.
Respondent number 4.
Standing council.
Standing Council Assam.
Assam University appears for respond number 4. Stop. Who is the private respondent?
My lord, they are the, my lord, respondent number 5 is the bank, my lord, by which this illegally constituted committee is now transacting. We have made him as a formal party, but our grievance is against respondent number 6, my lord. 5 and 6, my lord, we registered post, and we can take Dasti also.
Sir, copy of the position
My lord.
to the standing council SCRT. with
My
the
lord.
course of the day. Stop. Para petitioner takes steps for service of notice on the respondent. 5 and 7. By registered post ID within 1 week.
May I pray, my lord, that the constitution of 6 may be subject to outcome of that observation.
This the matter after 4 weeks.
My lord.
The constitution of the
Respondent number 6 committee, my lord.
of the
Patharkandi College of Education, my lord.
the governing body of the Patharkandi College of Education,
My lord.
Patharkandi. Shall be subject to the outcome of this.
My lord.
The constitution of the
Yes, yes,
governing body.
yes,
The constitution of the.
much obliged, my lord. Highly obliged.
To
May I please? This compassionate appointment, Mr. Miller. My father was died, my lord. 2011. Since then, my lord, I am applying, but not responded, my lord. In a similar case, my lord, this court.
Have you got any instruction?
My lord, as per instruction, my lord, no proposal has been found till date in the name of the petitioner
for compassionate ground. This is an instruction of the deputy commissioner, my lord. So the proposal has to come from the concerned department, my lord.
Has the concerned department received the application?
That I am not aware, my lord. My learned friend will make some.
Kaushik?
Lordship can. Take my lord. My lord can direct my lord for placing it before the DLC, my lord, if not placed. I think.
When did you make your application?
My lord, I made an application on my lord 6/12/2027, my lord. In a similar case, my lord, this could direct to the DLC to page 27.
Where's your application?
Page 27, my lord.
Whether this has been received?
There is a counter signature. It's
Yes.
deputy inspector. Now, due to the change of the district, my lord.
Maybe.
Okay, heard, Mr.
And Burman.
N. Burman and the consequent application. Also heard Mr. B. Kaushik, when it's standing council,
Elementary, my lord.
elementary education.
3, 4, and 6.
For response 3, 4, and 6. And Mr. G. Bekul and the government advocate for respondents.
1, 2, 5.
1, 2,
5. And 5.
The father of the petitioner. He was serving as what?
My lord, head pundit. At Nong 155 Ujoni Serapati Primary School.
Who was serving as head pandit at number 155 Ujuni Tier 5 Primary School. Died in harness on 4/9/2011. Thereafter, how much? Petitioner made an application for appointment on compassionate grounds on 6/12/2011. As the case of the petitioner is yet to be placed before the concerned DLC till date, petitioner is before this court by way of after hearing the parties, district petition is disposed of. Directing the inspector of schools.
Inspector schools.
Is it the party? There's no party here.
It could be DEO, my lord. District Elementary Education Officer.
Directing the response number 6. To place the application of the petitioner for appointment on compassionate grounds. Before the DLC, concerned DLC
Consent.
in its next immediate sitting. If not already placed.
All right.
With the above directions. Good petition.
Deeply obliged.
Before that, we just put, if the case of the petitioner has been placed before the DLC, concerned DLC, the outcome of this, of such consideration shall be communicated to the petitioner portal.
Deeply obliged.
3 and 4.
May I please? My lord, in both the my lord, cases, my lord, there is an interim protection to the petitioners. Now, my lord, lordship kindly see the my lord second case. My lord,
Lordship, notice already issued, it should come on admission column. Lordship.
Notice issued.
Notice issued,
Madam.
Lordship.
I think my lord,
Once-
in the my lord,
seven-
first case notice was not issued, my lord.
1785/23 on 31/3/23 notice was issued.
Yes. My lord, 5045/2022. In that case, my lord, notice has not been issued, my lord. So let the notice be issued, my lord. And in the meantime, my lord, there is a my lord process, my lord, under the my lord, respondent authorities. And there is a my lord, communication to the my lord, petitioners, my lord, saying that there would be a my lord, hearing on the my lord, subject matters by the departmental secretary. So since the my lord, representation is under active consideration, let the notice be issued, my lord. In the meantime, my lord,
Head MU Mandal and.
Lordship may issue only notice because already we have rejected it. As per Lordship's direction, we have rejected it. Displaying order is there, page 80
You
Lordship.
pass separate order. No? In item 5045. Head MU Mandal and council for the petitioner. Issue notice. Mr.
Lordship, I am representing 1 and 2 Lord.
K. Gogoi and standing council.
2 and 4 Lordship.
Higher education. Request for respondents
2
2
and 4 Lordship. Okay.
and 4.
1 is my brother Pegu Lordship.
And Mr. G. Pekul and Governor Advocate, request for respondents 1 and 1. G. Pekul for respondent 1, K. Gogoi
For 2 and 4 Lordship.
2 and 4, finance.
Solia.
H. Alia,
Yes, Solia.
Leonard Standing Council Finance, affairs for respond number 3. Stop. Petitioner to take steps for service of notice on respondent 5 and 6 by registered post AD. Within 1 week from today, this the matter of 4 weeks. Interim is there?
my lord.
Interim order for today to continue. In the In the other case,
Second case, my lord, notice has been issued, my lord.
On 31/3/23 Lordship notice was issued.
okay. Interim is here also?
Yes. In the second case, my lord, interim.
Interim is not there.
Yes,
It's just for consideration of your representation, isn't it?
yes. Now, last part, there is an interim protection there. The impugn order subject to the outcome of the writ petition.
Does this
My lord.
not required? In the second case, you see heard MU Mandal and counsel for the petitioner also heard Mr. K. Gogoi, and standing counsel and for the higher education. This matter.
Returnable, my lord, for 4 weeks. Diplopus.
May I please the Lordship, my senior lacks in another work, can it be passed over for timing?
Who's your senior?
A.M. Borbuy.
There was the matter relates to provincialization. Probably if Lordship pass over the matter, because these matters will go to the special bench.
To list it after the summer vacation.
Yes.
On request from Yago M. Barboyer, then the council. List of the summer vacation.
May I please, Lordship? Lordship, in this matter, Lordship, my senior could not appear on today, Lordship, due to his personal problem, Lordship. He was ill, Lordship. Kindly. fix it
Item
in
6.
Item 6.
Who's your senior?
B.K. Gogoi, Lordship.
On request, Madam Mr. D. P. Gogoi, then the council for petitioner. List up to the summer vacation.
Obliged, Lordship.
7.
In this case, notice may go to that other respondent except Union of India man, because they have their own standing council.
NIOS.
What is this matter about?
My lord, the petitioner, my lord, took admission in the DLED course, my lord, 2 years diploma course, my lord. And he appeared both the exams, my lord. But in the final result, my lord, he found that in 2 subjects, my lord, she has been shown as absent Whereas the principal, my lord, he has sent the practical marks. Those papers are practical papers, my lord. Kindly see page 20. Well, is the admit card, my lord. Now, my lord, in the below, my lord, there is a table. First year theory paper, then in right hand column, my lord, second year theory paper, and below, my lord, practical courses. There is certain subject code, my lord, 511 and 512. These are the first year practical papers, my lord. Now, my lord, in the final result, on page 21. Page 21 in the middle portion, my lord, subject code 511 and 512. In the, my lord, result, my lord, AB, that means absent. Now she has been shown as absent. Thereafter, my lord, the petitioner approached the principal of the college. He first assured her that he will do something. Finally, he has sent a letter, my lord, on in page 23. My lord, it is dated 5/4/2022. That is to the regional director of NIOS, Guwahati, my lord. Subject prayer for marks upload in 511 SBA and 512 WBA. School-based activity and work-based activity, my lord. Sir, respected sir, with reference to the subject cited above, I have the honor to state that Neha Shah, bearing roll number so-and-so and reference ID, reference number so-and-so, was the candidate of DLED NIOS of our institute. Sir, due to some technical fault, her marks of 511 SBA.
Yes, what happened after this?
My lord, along with this letter, my lord, there is a mark sheet, my lord, he has appended here, page 25.
Yes.
In the right hand side, my lord, SBA 511, she obtained 60, and 512, my lord, she obtained 68. Now the NIOS has to, my lord, upload the mark in the website and issue a mark sheet and certificate in favor
Who
of it.
appears for NIOS?
So they have their.
There is no standing council, my lord.
Who's the standing council?
He is not from here, madam, from Delhi, madam. Not from here. madam.
Then you take steps.
Yes.
Notice may go, my lord.
Third, Mr.
M. Ali.
M. Ali, learned counsel for the petitioner, issue notice. MS.
Egan for responding.
Learned CGC.
CGC.
Address for respond number 1. Stop. Petitioner to take step for service of notice on respondents 2, 3, and 4 by registered for CD within 1 week from the date. Stop. Use the matter after 4 weeks.
Obliged. 8.
May please lawsuit. My lord, in this matter, my lord, I mentioned, my lord, I have to receive instruction, my lord. So the matter may be adjourned, my lord. It may
This
come
is-
after vacation, my lord.
This is basically a matter where an assistant professor is seeking promotion to the post of associate professor in an Ayurvedic college. Now, all past practices and uses have could show, I have annexed those documents, that this is a promotional post. But herein, I am aggrieved that they are now advertising that post to give it under direct recruitment. So that was my challenge per se. On the last occasion, there is another post that is vacant. Last occasion,
Hello?
there was an understanding that they will bring the instruction as to whether promotions can be given to me in that particular post or not. So that
Because-
instruction is awaited, lordship.
Because on last occasion, my lord, because the petitioner, assistant professor, he is seeking promotion to the post of associate professor. So in the advertisement, only one post has been advertised. So there are 2 posts of associate professor. So my lord, DPC has to be constituted or something, my lord.
That instruction has to be put
So
forth
the-
before your lordship. So
I
what has
need
happened?
some
I do not know.
instruction. Otherwise also, my lord,
Whether the post advertised is the post held by the, where the petitioner is claiming from, correct?
yes.
No, it's a post to the higher cadre.
That's why.
This is a professor. I am an assistant professor, but I have the eligibility of 5 years in the post of assistant professor. So I am entitled for promotion.
He is
Past
basic,
practices would indicate that this is always a promotional post. I have annexed those documents to
his
indicate. that.
basic grievance is there my lord, since one post has been advertised, he may not be promoted.
Yes.
But one post remain still not advertised.
But
So
there is
otherwise
another,
also his rights will be protected, my
there is
lord.
another aspect. If the direct recruitee is promoted first, I lose my seniority. So that aspect also has to be looked into because I am serving in that college itself, in the feeder cadre.
What is the stage of that advertisement?
No, advertisement is still not recruited, my lord.
Interview
not held
dates
yet,
have been
my lord.
now given, lordship.
Interview not held yet, my lord. So it will take some time, my lord. So
When is the date given for interview?
27th, lordship, 27th of June. So I have some urgency in that aspect, lordship. Or if I am protected, let them not finalize, lordship, that recruitment process.
Yes, Bora,
yes, my lord. My lord, one post is there, my lord.
one post is there, supposing if the direct recruitment is appointed first.
My lord, in that case also, this case will be pending, my lord. So he can ventilate
So
his
let it not
grievance
be
in that case, my
finalized.
lord.
Let that process continue, but
Because,
let them
my
not be
lord,
finalized. Because otherwise, I also cannot apply for that because I am already over age. There is a age barrier. So that way is my avenues are closed from that sense, lordship. And I can show, lordship, at page 34, 39, 41. Always this post has been by way of promotion, it has been filled up. I have annexed all those documents, lordship. 34, 39, 41.
As
So
a
if
matter
it can-
of fact, one post has not been advertised because of him, my lord.
So if I am promoted therein, I have nothing to say. But then
So, my lord, the
situation is
matter
such.
may come after vacation, my lord, and
Third, Mr.
Yes, sir.
Sharma, then the constituted petition. Stop. Mr. B. Bora, then the standing
DP Bora.
council, the DB Bora, then the standing council, health department. Submits that he is yet to receive instructions. And prays that the matter be listed up to the summer vacation. Prayers allowed. List up to the summer vacation.
oblige, my lord.
In the meantime, lordship. In the meantime, lordship, if the
No, my
post
lord,
cannot be filled
regarding
up.
seniority, this
See that one, since
Uh,
just one post. We can protect your seniority.
yes, my lord.
If that observation may be recorded, his
This petition is otherwise also.
submission may be recorded.
Oblige, my lord.
Lordship has given a date.
I'm not giving a date.
Lordship, kindly give a date, at least that.
After vacation, there's a problem.
Immediately after vacation, lordship.
After vacation.
Immediately after vacation.
Oblige.
Oblige, your lordship.
Nine.
May I please, your lordship, my lord, I am on behalf of Mr. J.L. Loskur, my lord. He is not feeling well, my lord. Matter may be adjourned for 1 week, my lord.
On request made on behalf of J. Last Garden, council for the chair. This is the matter of 2 weeks.
J.L. Loskur, my lord, council petitioner. Oblige.
10.
May I please, your lordship? Matter-
After vacation.
What?
Instruction is awaited. Instruction is awaited.
But MSA Bajubara, that is council for the. On request made by Mr. S. Bora, then a standing council,
VTC law.
VTC, Mr. Bhatta, summer vacation.
Date may be fixed, my lord, after vacation.
Problem.
11.
May be please your lordship. Lordship matters relates to completion of appointment lordship. Petitioner's father died 1/1/5/2007 and petitioner applied on completion of appointment.
Have you filed that additional affidavit?
Yes, lordship. Showing the date of the application. Petitioner applied on 19/5/2007 lordship. DLC 5, its meeting dated 24/1/2011 lordship, case 42.
DLC meeting?
24/1/2011.
Yes.
Case 40 lordship. His page 40. Did not consider his recommendation.
Page
Page 40,
40.
Devojit Rajvanshi.
Page 40 is something else.
Relevant portion is 40, Lordship. His name is shown in page 40. Devojit Rajvanshi. His recommendation is not considered on 2011. After that, DLC meeting was held, but his name was not forwarded.
No, what is this? Page 40.
Page 40. Relevant portion, Devojit Rajvanshi, Lordship. 24/1/2011. My note dated. Did not consider his recommendation. After that, the DLC meeting was held, but his name is not forwarded.
It was rejected, isn't it?
Yes. Yes, Lordship.
2011.
11.
Then
That after that, several meeting is held, Lordship, but
no, DLC rejected your case in 2011. Is it
yes,
correct?
yes, Lordship.
So there's no point, there's no question of placing your case before the next DLC. Read the last line. There were 21 proposals, applicants, out of which only 2 were forwarded, recommended,
Not considered.
and the other 19 proposals could not be considered by the PLC. Is this a rejection or what, Mr. Begum?
It's not clear, my lord. But it is implied, my lord, that they were not rejected, my lord.
Not rejected,
Rejected.
rejected.
Because out of there were 41 vacancy position was 41. So 5% of 41 will be two posts, my lord. And accordingly, 2 proposals were sent to the SLC and other 19 were rejected for the
Yes.
want of vacancy.
Yes.
Lordship reads the letter, next is my senior will argue this case.
Okay. On request made on behalf of MSP Devi, the council, please the matter up to the summary.
Yeah.
May please, Lordship, my lord, petitioner is differently able person, my lord, with benchmark disability, my lord. Pursuant to an advertisement, my lord, petitioner applied for that for post. And he got selected, my lord, and thereafter, my lord, appointment order also issued, my lord. Page 37. But he has not allowed to, my lord, join the post. Well, only because, my lord, some clearance from the government in personal department is necessary by saying this.
This is the appointment order.
My lord, page 37.
Hmm.
Kindly see, my lord, page 37. Term and condition last, my lord, 8. Last number, 8 number. The appointee shall have to join in the respective place of posting from 1st June to 15 June 2023, positively without fail.
Yes, then
But thereafter, my lord, in the next, kindly see page 38. By order date 35/2000, my lord, 23. Petitioner, my lord, has not been allowed to join only because, my lord, some clearance from the government in personal department is necessary, my lord, is required, my lord.
Yes, my lord. Personnel department is the necessary party in this case, my lord. Because the entire exercise of keeping their appointments on hold is based on the personnel department's report, my lord. And I have been told, my lord, the personnel department has also constituted some boards, medical board. So they will be in. Only they can say, my lord, why, what was the outcome of the medical board.
Yes,
My lord, kindly see page 28, annexure D, my lord. This is, my lord, unique disability identity card issued to the petitioner in terms of, my lord, sub-rule 5 of,
that we know.
yes, my lord. So, my lord, it was
Here
issued on,
Issue is after an advertisement, you were selected.
yes, my lord.
After selection, you were given the appointment order.
Yes, my lord.
After the appointment order was
Made,
issued,
yes,
it was kept on hold
yes, my lord.
for verification of your disability status
Yes, my lord.
on the direction of the personnel department.
Department, yes, my lord.
So personnel department is a necessary party here
Absolutely.
so that they can give the instructions for what reason they have issued that.
That is the- সহি করা কত কাগজ জানেন এডুকেশন জানেন but my lord this was issued, my lord, by the respondent number 4, my lord.
That's fine. It was issued by the response number 4. There's no problem on that. But read the heading.
The first line itself, my lord, indicates.
The response number 4 is only following the direction of
Yes.
the personnel department.
My lord, as per rule, sub-rule 5, rule 18, my lord, my lord, UDID card was issued on 8/5/23.
That is not the issue now.
Yes, sir.
Everything is done.
Yes, ma'am.
Appointment order issued. This was kept on hold
Yes.
on the direction of the personnel department. On the ground that they want to verify your disability status. So let us have the personnel department as a party. Let's see for what reason they issued this.
I এখন file করে দেব।
Yes, ma'am. That is the.
Then
Then, my lord, I may be allowed to make them party, my lord. Take the personal department party.
you'll have to make a
Yes, ma'am.
file an IA.
Otherwise, my lord,
Mr. R.S. Jawan, run the counsel for petitioner. Praise for how much time?
1 week, my lord.
1 week time. To file an appropriate application for impeachment of the Department of the Personnel Department Assam. Stop. Praise a lot. List after 2 weeks.
13.
Oblige. No.
May I please, your lordship. Lordship, this matter pertains to compassionate appointment, your lordship. Impugn order is page number 39, your lordship. This is relating to the balance of service, your lordship. That is
Page number
39 annexure 8, your lordship. 39. Lordship, may I kindly peruse annexure 9, page number 55, your lordship. Page number 55, lordship.
Yes, Begu.
I leave it to your lordship because in some cases.
Third, Mr.
R.H. Chaudhary, your lordship.
R.H. Chaudhary, run counsel.
In some cases, notice are issued, my lord, because since the appeal is pending, my lord.
There is no stay, Lordship, and already
There is no
got
stay.
it. No stay, Lordship.
Also heard Mr. who appears for elementary. J. Begu, learned standing council, elementary education, appears for respondents 1 and 2.
1, 4 and 5. 1, 2, 4, 5.
1, 2, 4, 5. And Mr. J. Begu, learned government advocate, appears for respondents
3 and 6.
3 and 6. Stop. Para. The father of the petitioner, while serving as a teacher in assistant as a teacher. Is it a teacher or assistant teacher?
Assistant teacher, Lordship.
While serving as assistant teacher in Bonogot ME Madrasa under Haila Gandhi Education Club, died in harness on 23/10/2016. Stop. Draft petitioner met in application for appointment on constitutional grounds on 20/10/2022. Stop. Para. Case of the petitioner was considered by the concerned DLC in its meeting held on 5/10/2021. Where's the original one?
Pardon, Lordship.
Where's the original? In its meeting held on 5/10.
5/10/2021. Annexure 39, Your Lordship. Sorry, Annexure 8, page number 39, Your Lordship.
However, his case was rejected on the ground that the remaining balance period of the service of the deceased employee was only 8 days. Now, para. The close one of the OM dated 1/6/2015 has been set aside by this court by judgment order dated 31/2023. Passed in WBC number 1646 of 2021. On the ground that it is violative of Article 14 of the Constitution of India. Accordingly, the matter is remanded back to the concerned DLC to reconsider the case of the petitioner on its own merits in its next immediate sitting. By also in its next immediate sitting, by also considering the fact that clause 1 of the OM dated 1/6/2015 has been set aside. So
That observation, when an appeal is pending, there is no stay order, that line may be recorded, my lord. Because there is a difficulty, my lord. Today, suppose tomorrow if the appeal is allowed, my lord, and government wins the case, then what will happen to this? So that line may be recorded, my lord.
which is on top where I said clause 1 has been set aside, so by that in order to so no. It is stated at the bar that an appeal has been preferred before the honorable division bench against the judgment order dated 31/2023. However, there's no stay order. However, no stay order is passed by the division bench. Stop. That will pass.
Apply.
14.
May it please your lord. My lord, the petitioner is the father of the minor girl, my lord, who appeared in class 12 examination. My lord, in pre-board and in pre-board 1 and pre-board 2, in class 10, in class 11, she stood first in the school. That is where she was studying. That is JNB Bongaigaon. Now, my lord, when she appeared in the CBSE examination on for 12th class, my lord, result came out and she got 6 marks in biology. And physics, chemistry and maths also very lesser marks. Then she call for verification of the answer script, and photocopy of the answer script were submitted to the petitioner as per the guidelines of 2023. When they have gone through the answer script, it appears that in biology paper, from page 3 to 12 were torn. Similarly, in physics paper also, several papers were torn, and chemistry papers also, several several pages of answer scripts were torn. Then he represented before the authority, stating his grievances. Even the mathematics answer script, which was furnished by the CBSE, is not of the petitioner, my lord. That is daughter of the petitioner. Why, my lord? That she has stated at page 27, NHR 5, that is the representation. Third paragraph, today, my lord, today, on 2/6/23, the CBSE has provided the photocopy of the answer sheets as applied, and then only it came to our knowledge that pages number 3 to 12 had been torn in biology, which is unexpected. The child again, so going through the photocopies of physics page, missing from 3 to 4 and 18 to 25, and chemistry page missing from 11 to 16. The student also identified that the maths copy does not belong to her, since she did all rough work, even for MCQ questions on the right hand side. Not only this, due to removing of papers from answer sheets in physics, pages containing questions from 1 to 19 and question 33, 34 and 35 are missing. My lord, CBSE is such a vast organization, holding the examination throughout the country. My lord, near about 5,000 schools are there under CBSE board. If a board like CBSE, they conduct the examination of a minor child, my lord, her future will be jeopardized if such type of activities are going on.
Yes,
so
sir.
at this stage, what I pray before your lordship, let them take instruction on that, and matter may be fixed on 28.
Lordship, I have the original mark answer script with me. During the examination time, 2 invigilators, examiner, and the superintendent, central superintendent was deputed, and their duty was to take the book answer script from the student, and then they never see what is inside the book are like this, lordship. Why they will examine the inside the book, they give the book like this, and they took the book, and after that, with proper care, they have sent to the CBSE. Not only one answer script she has torn, every 5 subjects except English, 4 subjects she has torn out all, and that examination evaluator report is there, lordship, in the marks itself, in the answer script itself, that it was found torn. So CBSE has nothing to do. But what happened, lordship? They have claimed that the mathematics and the physics, mathematics does not belong to her, the book. She tried to turn out. Actually, for us, I think who will do all these things, lordship? Not in one subject, every subject. Who will do, lordship? Whether invigilator or central examiner, or will you go to do to turn out her examination book, Lordship? What is that? They do not know her. She has given examination in the different center. So who will do, Lordship? She tried to turn out these pages. We are saying that she must be doing herself because she could not turn out. It was like this, and we have received like this, and other subjects also. She said that that book does not belong to her because she tried to turn out the pages. All the mathematics answer is wrong. Such a new variable. All the answers is wrong, Lordship. Cross. She got only 32. And this physics paper, Lordship, somebody has thrown out like this. So that report is there, invisible report is there. The pages has been found on. Present past invisible should examine the copy. It was found on, Lordship.
My
Not
lord,
in one subject,
my,
every subject.
my
Each
lord,
and every subject.
my
Who will do,
answer will
Lordship?
be this.
Who will be her anyway to do all these things, Lordship? In every subject, not in every subject, she has torn out every pages. Very interesting, Lordship.
Okay, you file your affidavit.
Lordship, I'll pay the fee.
Only one thing, my lord. Kindly consider the examination room is full of candidates.
That's why.
There are
go
two
to do all these
superintendents, two invigilator, and the flying squad.
They are
Is there
very
any
strict,
opportunity of any candidate to turn his paper?
Hurt Mr. G. Vaishya.
Ji, Vaishya, my lord.
I file affidavit, Lordship. This is a false allegation against CBSE, Lordship. The candidate
Who
herself has
appears
torn out
for
all pages.
Respondent one,
Once is appeared.
MS.
On behalf of Kate.
No, no.
On behalf of Kate.
Council appearing on behalf of Mr.
Is Kate.
K. Fukan. No, no, CGC.
Yes.
Appears for respondent number one. And you are appearing for
2, 3, 4.
an MS
Boral.
R. Boral and a standing council.
CBSE.
CBSE appears for respondents 2, 3, and 4. Stop. How about respondent 5, director CBSE? That also you will appear, I think.
No, S1 5 is the principal, Kendriya Vidyalaya, Bangladesh.
Director. 2, 3, 4, and 5, I think.
No, 5 I cannot appear. Let's say it's a principal, Kendriya
No.
Vidyalaya.
5 is director. Director CPSC, regional office.
Oh, correction position again. Oh, sorry, yes, 5. I do not know. I have copy, Lordship. 5 is.
2, 3, 4, and 5.
Oh, अच्छा.
Petitioner to take steps for
Yes,
service of notice on the respondents 6 and 7 by the state court within 1 week. Respondents are allowed to file the court affidavit. This is the matter of the courts. Come to the mic, I can't hear you.
Asal correction copy to my
You are appearing for?
My lord, this party names has been amended, my lord. I'm for respondent number 2 and 6, my lord. 2 is NVS and 6 is KB, my lord.
And 3, 4, 5.
Okay, Mr.
D does.
D does, then the standing council.
My lord, I'm on behalf of RS Chaudhary. He is the standing council, my lord.
The council appearing on behalf of Mr. R.
RS Chaudhary.
R.S. Chowdhury.
My lord.
Then the standing council NVS
MS.
appears for respondents 2 and
2 and 6, my lord.
6. MS Boras.
3, 4, 5.
How about 7?
7.
My lord,
You've not
Seven-
supplied, you've
seven-
not supplied them the proper.
There is no 7 in my petition, my lord.
Yes, what is going on, Mr. Bhatia?
my lord,
What, how have you supplied copies?
my lord, for 7, my lord, notice will go.
But have you supplied the corrected copies to
Yes,
the other side?
I supplied to them, my lord, only the CBSE, my lord, left. I'll give you just now.
Petition.
Allah really,
For service of justice
Puni
on
takan
respond
mo
number
ito,
7 by respect for city within 1 week. This is the matter of the courts. Respondents are allowed to correspond.
My lord, immediately after vacation, my lord,
After 4 weeks.
my lord.
Deeply obliged.
Obliged, ma'am.
15.
I have to copy.
May I please, your lordship? It's a matter of compassionate appointment, lordship. Lordship, in the time of submission, petitioner is underage, lordship. Only 24 days, lordship. But in the time of consideration of petition, it is she attained 24 years, lordship. Kindly page 30, lordship. In the time of submission application was 17 years, 11 months, 6 days.
Page.
Page 30, lordship. Annexure I. Last paragraph, lordship. After close scrutiny, the application was submitted. It was observed that the applicant was underage at the time of submission of application. Her age at the time of submission of application was 17 years, 11 months, 6 days. Only 24 days.
Yes.
But the main issue here is, my lord, last paragraph, my lord, page 30. The deceased employee died on 10/8/2002. And application submitted by the applicant on 1/1/2017, after 15 years, my lord. And accordingly, it was resolved that the application of the petitioner is not fit for recommendation to the SLC. That is the main ground.
It is not fact, lordship. Case is rejected only for age, lordship.
1 minute.
Last
On-
paragraph.
Only for age, lordship.
Where's the minus of the DLC?
Now it did not give us, lordship. Only order copy.
Issue is this, there are two issues. One is when, according to the order, when the petitioner made her application, she was a minor.
Minor.
Obviously, that means then she had made her application earlier to 2017.
No, but
Something is wrong here. Where's your application?
Application I am not.
Then, this is the issue.
It is already, main copy already submitted. So there is application, that's why they give this findings, lordship. We consider it a minor, lordship. He is the only.
Yes, my lord, it's correct, my lord, because at the time of death, the petitioner was only 4 years old, my lord. Page 24. So on the date of application means 2017, she was 17 years, 11 months. Page 24, my lord. Number 2, Saraswati Pal, 4 years, daughter. At the time of death, she was 4 years, and at the time of application, she was 17 years, 11 months.
When did she make her application?
17, my lord, 1/1/2017,
1/1/2017.
after 15 years, my lord.
But it is a clear judgment, lordship, in Supreme Court, I see, lordship. 5 years also he can apply. Lordship.
Where?
Till today I am not,
Where's the judgment?
till I not got my,
Is there a judgment of the Supreme Court?
lordship,
Age is not factor. In they can apply anything.
Begul, you get the minus of the DLC. My lord. Heard Mr. Alamgir and the council for the petitioner. Mr. D. Begul and the government advocate shall produce the minus of the concerned DLC of the DLC of the concerned district level committee which held its meeting on 5/10/2021. Now, whereby case of the petitioner was rejected on the ground that at the submission of her application, she was a minor. List after summer vacation.
16.
May I please, Your Lordship? It's a matter regarding Lordship highly agreed the judgment of tribunal, Lordship. Petitioner. The question is that petitioner is appointed in 2005, Lordship, Bencher School, Lordship. And private respondent is appointed in 1990, Lordship.
What is it?
Lordship, page. Question is that, Lordship, petitioner is appointed 2005. And private respondent is appointed in.
You approached this court earlier, isn't it?
Lordship.
Where's that writ petition?
Page 62, Lordship. Judgment, Lordship.
Yes.
Lordship.
No. Judgment passed by this court.
Tribunal, Lordship.
By this court.
Our High Court.
Yes.
Lordship, it is. It's just deducted the. Already dismissed and directed to file civil suit.
Where's that order? Yes. Then
Ashok, now in this judgment, Lordship, page 63, Lordship. The defendant number 1 to 8, except defendant number 7, are directed to enlist the name of the plaintiff in the list of teacher, assistant teachers, Sarvanandapur, Anarpar, Bencher LP School, Hailakandi, by removing the name of defendant number 7. Lordship. Lordship, question is that defendant number 7 is present petitioner, Lordship. And page 65 also, Lordship, it is. The plaintiff filed this April 2012, Lordship. And the official respondent, the state government, director of elementary education, district elementary education, deputy inspector of school, block elementary education, and headmaster, Lordship, and petitioner. But, Lordship, in this case, Lordship, the official respondent 1 to 5, they are absent, Lordship. They do not take any step, Lordship. Even if though it may not take the step, Lordship, it is required to issue warrant also, Lordship. They do not issue. Also, Lordship, I see the SMC is the main who has the authority to appointment, or also discharge the petitioner. But the SMC is also not party in this case, Lordship. Only the view of headmaster.
Did you take all those grounds before the tribunal?
Lordship. We have also already in cross also, Lordship, I think, and also in petition.
Where? Yes, who appears?
Lordship.
Yes, you can't. Why notice?
Otherwise, I need to be again traveling.
Why?
Because school is until Francis days, we don't have do nothing.
School is the venture.
Yes.
Venture.
But how are you aggrieved by this order?
Question, I am still I am in this school from 2005 to 23. Also, I am still continuous. But this private respondent is, though he is appointed 2019, Lordship, 1990. But Lordship, he is irregular, and due to negligence, SMC has removed this. And as proper advertisement, I was appointed. But when from 2004, she was already discharged. From 2004 to 2012, he cannot claim even if higher authority, also in court, Lordship. When 2012, Lordship, financial assistance is granted. In that time, she filed this suit, Lordship. He is also in there. But in official record from 2005, my name is there. Also, my name is in Dice Code also.
Well, consider the matter.
Yes.
Third age along here when the conflict of petition. Issue notice. MS and Fukan, the standing council. Elementary education, appraised for respondents.
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. Petitioner to take steps for service of notice on the respondents 6 and 7 by registered post within 1 week. Respondent allowed to file a counter affidavit list after 4 weeks.
17.
May I please as a lordship? My lord, the beloved matter relates to an order of my lord amalgamation had been my lord put into challenge. My lord may be pleased to find the amalgamation order is at Annexure 1 as per the recent policy decision of the government. My lord, under the Shiksha Kshetra scheme, my lord. My lord, what has happened? These two schools at under this, my lord, by this order, my lord may be pleased to turn to page, my lord, 26. The serial number 8, my lord, we have only typed the relevant part of the entire district. These two schools has been amalgamated. Uttar Sapekati LP new school with the page, my lord, I am referring Annexure 2, page 26, my lord. So, my lord, our grievance is that the government has taken away the land and all the movable and immovable property, my lord, as per this order, my lord may be pleased to find this movable and immovable properties consideration, my lord, is at page 23. The movable and immovable property documents recorded of the merged school shall be vested in the name of the base new school. My lord, the school which has been provincialized by way of, my lord, this Uttar Sapekhati new school, E-school, my lord, is the land now is going to be vested with the Uttar Sapekhati LP school. My lord, our grievance is that this land, although, my lord, it has been provincialized, it has been lying, my lord, unattended, no infrastructure, nothing is there lying unattended due to our voluntary, my lord, donation of the land in the name of the school could get provincialized, my lord. So now as for this, my lord, amalgamation order, the entire property is now going to be vested with the base school, my lord. My lord, this honorable court on certain occasions, my lord, there is a provision has been made My lord may be pleased to turn to in the office memorandum, my lord. Page, my lord, the page starts at page 45, my lord, annexure 7. And my lord, I am referring to the, my lord, my lord, clause, page 49 of my petition, my lord. 49, clause 19, I am referring, my lord. The director concerned will issue the necessary order of amalgamation for any dispute arising out of the order. The aggrieved institution public may appeal before the government in the secondary or elementary education department as the case may be. Now, my lord, may I humbly pray, my lord, as there is an appellate provision has been given, my lord. My lord, we have not yet approached with an appellate forum, my lord. Only after filing of this petition, my lord, this has come to the notice. So, my lord, the petitioner may prefer an appeal before the secretary elementary, my lord, and he will, my lord, and take up the issue, my lord.
Why are you approaching this court if you haven't that?
My lord, that mistake I have, my lord, I have done, my lord. That mistake I have done, my lord. Escape, my lord, and I thought, my lord, an appeal is preferred, but that appeal is not in order, my lord. That's why we have not annexed that, my lord. That is, my lord, to be admitted, my lord. It was in under a wrong forum, appeal preferred before the DC, my lord. DC has nothing to do, my lord.
Yes, yes. You are not aggrieved by the amalgamation.
No, my lord, agreed with the amalgamation. Amalgamation may remain only with the land issue we are here, my lord. That the land can it be, my lord, considered the issue of, basically amalgamation order is under challenge, my lord.
As per the. Malad. If my lord, they are not aggrieved about the amalgamation order, my lord, they should go to the civil court, my lord.
You're not
For the
aggrieved with the
land dispute,
amalgamation.
My lord, we are agreed with the amalgamation because due to the amalgamation, this land has been taken away, my lord.
Let us see the amalgamation order again.
Yes.
My lord, the amalgamation order is at page, my lord, 22, my lord. In pursuance of the government office memorandum communicated by number, page 22, my lord, dated and subsequent approval of the concurrence of the finance department, so and so. The governor of Assam is pleased to merge 45 LP school with 42 LP schools of Moregaon district under the scheme of Shiksha Kshetra. The details of schools are mentioned in Annexure B1. So, my lord, these are the terms and conditions. And if we go by, my lord, this clause number 8, the movable and immovable property documents, records of the merged school shall be vested in the name of the base new school. Now, this clause, my lord, we are agreed with of the, my lord, amalgamation order. Now, if anyone is agreed with a particular portion of the, my lord, this amalgamation, then they can prepare an appeal under, my lord, clause 19, my lord. That appeal, my lord, admittedly, we have not invoked till date, my lord. So, my lord, liberty may be given to approach the appellate authority.
Then let them have it. Heard, yeah, Goyal and also heard MS and spoken. Standing council.
My lord, respondent 1 and 3 months.
Elementary education correspondence 1.
1, 2, and 3, my lord.
1, 3.
1 and 3, my lord.
Revenue who appears?
I am appeared.
Mr.
J. Henry.
J. Henry, standing council revenue address for respond number 2.
I
And
appear for respondent number 4 and 5.
Mr. J. Bikul and government advocate address for respondents 4 and 5. So, Para.
DC appeal is.
The petitioners before this court
Appeal to ground it so far.
are the legal heirs of late Osman Ali, who had donated one bika of land to for the establishment of
Uttar Sabkhati
Prathamik Vidyalaya. Stop. The amalgamation draft, comma. The Deputy Secretary, no, Commissioner and Secretary to the Governor of Assam, Elementary Education Department, issued a notification dated 19 December 2017, merging 45 LP schools with 42 LP schools of Morigaon district under the scheme of Shiksha Khetra. Stop. In the said notification, the petitioner school, namely Uttar Sabkati LP
E school mein.
within bracket E school,
Itu amar no.
is merged with the Uttar Sabkati LP school, correct?
Milord, the below is our petitioner school, Milord. Uttar Sabkati LP school has been merged with Uttar Sabkati LP E
The
school.
petitioner school, namely Uttar Sabkati LP school, is merged with the Uttar Sabkati LP within bracket E
school.
Stop. Further, the notification in the terms and conditions of the said notification dated 19 December 2017, the terms and condition number 8
Mal.
provides that the movable oblique immovable property oblique documents oblique records of the merged school shall be vested in the name of the
Base.
within brackets new school. Being aggrieved, the petitioner is before this court
Mal.
by way of the present. Para. Clause 19
Mal.
of the office memorandum dated 3rd August 2021, issued by the Secondary Education Department, Government of Assam, provides that any disputes arising out of the order, any disputes with regard to any disputes,
Mal.
the aggrieved institution oblique public may appeal before the government in the secondary or elementary education department. Learned counsel for the petitioner, Nipara. Press for direction, allowing the petitioners to file an appeal
Mal.
in terms of clause 19 of the OM dated 3rd August 2021 before the appropriate authority. Accordingly, district petition is disposed of, directing the petitioners to file an appeal and under clause 19 of the OM dated 3rd August 2021 before the Secretary School
Mal.
Education.
Secretary Elementary Education.
Before the Secretary School Education.
School Education.
Government of Assam. Within a period of
15 days.
within a period of 15 days from today. So,
Within
after on receipt of the appeal, the Secretary School Education Department, Government of Assam, shall consider the appeal
Mal.
and dispose of the same by a speaking order
Mal.
and in accordance with law. Within a period of
3 months.
2 months, make it 2 months. Within a period of 2 months
2 months.
from the date of receipt of the appeal.
From the issue of this order.
Petition is dismissed. Yes,
From the issue of this order. From the issue of, from the date of the appeal.
Yes.
that's okay.
Obligement. Highly obliged.
18.
May I please as your lordship? May I please as your lordship? My lord, the petitioners before my lordships are the, my lord, education volunteers Lord, what has happened? There was a policy in the state of Assam as well as in the entire country, my lord, for the purpose of, my lord, those students, my lord, who are dropped out, or, my lord, those students and, my lord, who cannot afford the quality education. Immediately, my lord, after enactment of the Right to Education Act 2009, as the, my lord, elementary education has been made compulsory, my lord, these persons were appointed in the, my lord, education under the education guarantee scheme in the concerned, my lord, education centers. Accordingly, my lord, they have been continuing in their schools, my lord, and the time to time they have been given the remuneration and salaries also, my lord. Now, my lord, the details of the petitioners, my lord, I have, my lord, stated from paragraph, my lord. My lord may be pleased to find the details of the petitioners, my lord. It starts at page 170, my lord. From page 172, my lord, page to the, my lord, page 301, my lord. So, my lord, these are the conditions of the petitioners. Admittedly, my lord, the petitioner has all the educational and professional qualifications. Only, my lord, they are lacking the teacher eligibility. That qualification they admittedly do not have, my lord. So, my lordship, my lord, is well aware, my lord, that the as on date, my lord, if someone is required to be appointed as a teacher, then, my lord, the teacher eligibility test is a must. Now, my lord, in the state of Assam is so compassionate, my lord, and so, my lord, benevolent, that those teachers, my lord, who are working in the, my lord, venture educational institutions and who have been provincialized recently, my lord, a relaxation has been given to them that you acquire the other professional, or if some qualification is lacked, then they have been given an adequate time for the purpose of getting the qualification, my lord. Just for a moment, my lord, for that, I beg to draw my lordship's kind attention to page 105 of the education manual, my lord. Page 105 is a part of the, my lord, this 2017 Provincialization Act, section 2. U is the, my lord, part which I am referring, my lord. May I read, my lord? 2U, my lord, at page 105.
Yes.
Tutor means and includes the teachers, assistant teachers, classical teachers, and also includes the lecturers, assistant professors, associate professors, professor, principal, vice principal, demonstrator, headmasters, assistant headmasters, superintendent, assistant superintendent in a provincialized educational institution under this act, who are not eligible for provincialization of their services and whose services cannot be provincialized in the post of teachers under this act due to lack of his oblique her educational and professional qualification required as per the right of children to the Free and Compulsory Education Act 2009. So, my lord, the government has, my lord, considered the long pending service of these persons, my lord, who are not eligible and qualified. They have been given the status of the tutor. My lord, for these categories of people, my lord, who were also rendering their services voluntary or sometimes such like that. But for them, my lord, government has time to time conducted the special TET also. But these batch of petitioners, my lord, though they have appeared, but they could not qualify. So therefore, my lord, there is another provision under the Right to Free and Compulsory Education Act, my lord. My lord, may kindly take up. It is not available in the new book, my lord. This is the problem. Nine. Notun kitabkhanot nai. Oh, in the old manual, my lordship may be pleased to find, my lord. In the old manual, red one. Yes, yes, my lord. Yes, my lord. I am referring to, my lord, this provision of section 23, subsection 2, my lord.
Yes.
My lord, the qualification for the appointment and the terms and conditions of services of the teachers. Any person possessing the such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Subsection 2, my lord, where a state does not have the adequate institutions offering courses or the training in the teacher education, or the teachers possessing the minimum qualification as laid down under subsection 1 are not available in sufficient numbers, of the central government may, if it deems necessary, by notification, relax the minimum qualification required for appointment as a teacher for the such period not exceeding 5 years as may be specified in that notification. Provided that a teacher who at the commencement of this act does not possess the minimum qualification as laid down under subsection 1 shall acquire the such minimum qualification within a period of 5 years. So, my lord, this is the condition of the Right to Education Act 2009, my lord, wherein government can move the central government, my lord, for the purpose of relaxation of any of the qualification as prescribed under this RTE Act. By applying this provision, my lord, this tutor concept has been inserted, my lord, in the year 2017, and those persons, my lord, provincialized in the year 2021. By following this act, my lord, they have been given the relaxation part, and you acquire the minimum qualification within a period of 5 years. Now, my lord, basing on all these things, my lord, the petitioners association has approached before the government. My lord, may be pleased to find the last representation is at page 365, my lord.
Yeah.
Lord, prayer for relaxing from passing out the mandatory TET qualification with due respect and humility with the undersigned on behalf of the Education Volunteer Association Assam would like to draw your attention to the following subject matter that, sir, we the education volunteer were appointed by the government of Assam after following a fair selection process to implement the objective of the Right to Education Act 2013 and to fulfill the government constitutional commitment. Thereafter, we had been rendering our services tirelessly over the years for the physical, mental, and social well-being of the school dropout children in remote areas throughout the state of Assam. We had rendered our services in consideration of the mere rupees 3,000 per month, yet with the satisfaction all the authority concerned. So, my lord, this is the plea that sir, my lord, my last part at page 367, my lord, the prayer which we have made. That, sir, we therefore humbly pray before our benevolence to kindly exempt us from passing out the mandatory TET qualification so and so for the Free Act of 2011 and thereby regularize our services. Now, my lord, it is the discretion of the government. We cannot say, my lord, that our prayer should be accepted positively. They can also reject, my lord, by citing the provisions of the various laws or the why we cannot be considered, my lord. My only limited prayer, my lord, today is this representation may be disposed of, my lord, with the reason order, my lord.
Let's will turn to page number 365. My friend is pointing out it. It is representation before the minister.
My lord, that mistake they have done, my lord, we can submit a fresh representation to the secretary, my lord. That's all, my lord. It is the discretion of the government, my lord.
To the minister, it cannot be.
My lord, that is the mistake they have done, my lord.
And another thing I want to point out, my lord, on the very beginning, my friend said this is a centrally sponsored scheme. And the Union of India is not a party.
My lord. Press এটা দিব লাগিব। Press এটা দিল। Press representative.
Yes.
Hello, representation is pending before the minister, madam. Kindly see page 365.
That is.
Yes, madam. Prayer for election from passing out the mandatory
Correct,
TET
correct. That is in connection with 23(2). How this is required to be. Thank you, ma'am.
You are paying for SSA.
I pay for respond SSA, respond number 3.
But sir, you are going on the council. Also her time is N. Fukan, Learned Standing Council, Elementary Education for Respondents, 1 and 2. 1 and 2.
My lord.
And Mr.
That's for respond.
Vora, Learned Standing Council SSA for the respondent.
Missionary.
You are working as education volunteers.
Education volunteers, my lord.
No, they are not working. They were.
Some people are still working, but some are being, my lord, sacked by the
All,
authority.
now it is not, my lord.
All.
The scheme has come to an end, centrally sponsored scheme. If the scheme is continued later on,
My lord.
they may come into.
Yes, my lord, the scheme has been abolished of late. my lord. That is
The
correct.
petitioners
Fine.
before this court
Abolished করে দিয়েছেন।
were serving as education volunteers. We don't like it. under different
education guarantee scheme centers.
under different education guarantee scheme centers which were established for implementation of the provisions of the Right to Free and Compulsory Education Act 2009. Stop. The appointment of the petitioners as education volunteers were made after a selection process. Stop. But it was shut down, isn't it?
Yes,
That
madam.
scheme has
Shut down.
come to an end. Yes.
So now you are without any job.
My lord, my lord.
Where's the thing that's particular annexure?
My lord, annexures, it is a very voluminous, my lord. We have stated in details, starting from, my lord, page, my lord, page 100 and, my lord, 70 from page 172, my lord, 312, my lord. A detailed categorical, my lord, in which education block, in which school I was working, detail has been given, my lord.
The petitioners are from entire Assam.
My lord.
different district.
The EGS centers.
My lord. Is now no more in
Is
existence.
now no more in
My
existence. In as much as the scheme has been abolished by the government of India. Correct?
My lord.
Well, the scheme, it comes with a budget. The budget has come to an end, the scheme has come to, if the budget comes, it might start. madam.
Well, then let us not say much. Stop.
Matter no করে।
As the EGS centers have been shut down
আমি জানা বলছি।
due to exhaustion of funds. The petitioners presently are without any job. Stop. They also do not possess the teacher
eligible.
education test, teacher eligibility
Test
test
qualification.
within bracket TET qualification. Stop. As such, they are unable.
My lord, we are unable to apply for the jobs of
They are
teachers.
unable to apply for the job of teachers.
Teachers.
Stop. Therefore, being aggrieved, the petitioners had made a representation
My lord,
before the minister
my lord.
of
Education.
Education, Government of Assam. By representation dated 2/6/2022. Praying for relaxing the mandatory
That qualification.
TET qualification in respect of the petitioners
My lord.
and permit them to appear or to
To
apply for
any job.
for any teacher post.
My lord.
Stop. Para. After hearing the learned counsel for the parties, it appears that the representation dated 2/6/2022 is met to the Minister of Education,
My lord.
Government of Assam, and not before the appropriate authority. Accordingly, this petition is disposed of, directing the petitioners to file a representation,
Fresh representation.
a fresh representation before the
Secretary, Education, School
Education,
Education Elementary.
one, before the commissioner and secretary.
Before the Secretary, School Education Department, Government of Assam,
My lord.
within a period of,
My lord, 10 days from today.
within a period of 2 weeks, with effect from today. Stop. So after, on receipt of the representation from the Secretary, School Education Department shall consider the same and shall consider and dispose of the same by a speaking order and in accordance with law within a period of
2 months.
2 months, in a period of 2 months from the date of receipt of the representation. To the application of the options in the petition that disposed.
Obliged.
19.
Lordship may please. The petitioner was appointed as an assistant teacher by governing body resolution dated 1911-2007. Annexure D, your lordship, page 37. Page 37. My name is Biraj Sharma. My name appears at last three line, your lordship, of the resolution dated 1911-07. Sri Biraj Sharma, son of Sri Khoghan Sharma, has been appointed as an assistant teacher in the vacant post of Sri Khoghan Sharma release order. And thereafter, your lordship, the school wherein the petitioner worked, it provincialized by the order dated 15/5/2013, your lordship, at page 43. Lordship, page 43, the order of provincialization of the school, order dated 15/5/2013, and lordship, the detail of a school at page 44, your lordship. The school wherein I worked, as your lordship got it, my lord, page 44, Purnadev LP School. And in the column, your lordship, last column, 1+1, number 1 is the headmaster and assistant teacher, wherein I was working. I've been working, my lord. But due to underqualified, your lordship, because I didn't have the required qualification on the day, so my service was not provincialized on the very day. Your lordship, subsequently, I got qualification, HSS qualification, a required mark, your lordship, and which I acquired on 9/4/2019. Your lordship, kindly mark it. 9/4/19, Annexure C. I have annexed the certificate, page 36, my lord. My name is Biraj Sharma. I have acquired more than 45% of marks, my lord. So, your lordship, what happened? Along with DLED, I had the qualification, my lord. What they did, your lordship, there's the respondent number 2 forwarded my case for provincialization, but they did not do so, your lordship. By the order dated, your lordship, 4/12/2015, page 56. Lordship, communication was given by the director to the commissioner. On page 56, on 4/2/2015, with reference to the subject cited above, I have the honor to forward here with the proposal submitted by DEO Jorhat by so and so for provincialization of service of Biraj Sharma as assistant teacher in Purnadev LP School under Majuli Education Block. The government instructed in the post sanctioning letter by so and so mentioned under reference not to be provincialized the service of teachers whose names appear in Annexure A and close to the sanction letter. The name of Biraj Sharma is also appeared in the state so and so. Accordingly, his service has not been provincialized by this office till now. Now, DEO Jorhat has submitted a proposal along with the relevant document, including mark sheet and certificate of Biraj Sharma. I therefore request the government kindly to issue necessary instruction on the proposal submitted by the DEO Jorhat for provincialization of service of so and so as assistant teacher in Purnadev LP School. Lordship, then thereafter, my lord, the communication between the various respondents, my lord. Individual profile was also submitted on 21/2020 and Annexure K, my lord. And by Annexure L, respondent number 6 submitted proposal of drop teacher for provincialization service as per new Provincialization Act 2017. At Annexure L, page 65 and 66, your lordship. My name appears at page 66, your lordship. My name is Biraj Sharma. Vacancy due to underqualified. Still, as on date, the post is vacant. Your lordship will kindly note that part. But what happened during the process of communication between the respondents, development was going on. The respondent number 2, by communication dated, my lord, 14/11/2022, have rejected the proposal, my lord, at page 83, my lord. With reference, page 83.
83.
Yes, my lord.
This is a copy of the judgment. Oh, okay.
83, your lordship, annexure R.
Yes.
My lord. With reference to the subject cited above, I would like to furnish following information regarding petition submitted by Biraj Sharma dated 26 to 2022 under Jorhat district. As per Provincialization of Service Act 2011, as amended in 2012, DEO Jorhat submitted proposal for provincialization service of teachers of Venture LP School with recommendation of DSC Jorhat. In the said proposal, the DSC recommended the following two teachers against Purnadev LP School. The said proposal, my name is there at page 84, Biraj Sharma. The said proposal placed before the SLEC. After verification of the document, the SLSC recommended the above teachers for provincialization of services against Purnadev LP School, including name of petitioner Biraj Sharma. Therefore, DE Assam submitted proposal for creation of post to government, accordingly government sanction 252 posts of assistant teachers against so-and-so LP school under Jorhat district. In the said government sanction letter, government enclosed a list of teachers as annexure A with an instruction not to be provincialized and post sanction against the school concerned are to be kept vacant, as they were found to be ineligible as per reasons cited against their names in the list. In the said list, the name of petitioner Biraj Sharma, assistant teacher, was listed with a reason underqualified. The government issued notification number so-and-so, published in the Assam Gazette number so-and-so of the elementary education, was amended as assistant teacher minimum qualification higher secondary or any other examination of equivalent standard, having 45% mark in any of the qualifying for general categories, and minimum 40% marks for reserved categories shall be minimum qualification for the post of assistant teacher in lower primary and upper primary school, with a direction that his notification will come into force from the date of publication of official gazette. From the above notification, it is clear the requisite qualification LP school teachers with effect from 10/11/2005 is higher secondary or equivalent examination pass, but Biraj Sharma was appointed by SMC of Purnadev LP School on 10/11/2007, having only HSLC as education qualification, and joined in the school on the same day, which reveals that the petitioner was appointed violating the qualification criteria as laid down in the above mentioned so and so. Lordship, but on the date, my contention is that on the date when the school was provincialized, the rule will be applicable on the date the post was created, my lord, not prior to that year or after that year, lordship. On the date when the school was provincial, I had the qualification. Although I didn't have the proper marks, I subsequently qualified myself. I given representation before the authorities. But as on date, nothing has been done. In between, what happened, your lordship? Prior to that, our school got provincialized with another school, my lord. Amalgamated with another school. I have annexed Lordship page O, annexure O, page 72 to 77. Petitioner school was merged with 47 number Sumoimari LP School of Jorhat district under Siksha Kshetra, where petitioner school is a list of 36. I have annexed it, your lordship, but I am not allowed to work in the school, in the amalgamated school. But as per the rule of amalgamation, all the school of the school which will be amalgamated with the later school, their service has to be continued, my lord, as per the rule of amalgamation, my lord.
Yes. Okay.
May I plead your lordship? Lordship, at the time of provincialization, he was unqualified. And my lord, another thing is that the representation is pending before the ADC, my lord.
But then I think we'll issue notice here.
Yes, my lord.
Lordship, may I pray for
Notice
stay of the
pending is-
impugn order?
Which order?
Lordship, annexure R, page 86, 82 to 89, my lord. Page 83.
It's only a communication.
Lordship, pursuant to that, I was not allowed to work. And one more factor, my lord, the school wherein our school has been
So, my lord, this order
amalgamated.
was passed 14th November 2022.
Yes, my lord. Then thereafter, I have submitted representation before the authorities concerned, your lordship, one after the another. They did not do so, my lord. Although they've assured us, your lordship, that my case will be considered, my lord, since I've acquired the qualification. But nothing has been done, my lord. Lordship, may I pray, your lord, I may be allowed to work, your lordship, because I have been working for 2007, my lord.
We'll consider the interim on the returnable debt. Let her get instructions.
My lord. Or otherwise, my lord, representation, kindly direction may be given them to dispose of this
That-
representation.
I don't think will work out much.
No, my lord.
But MSB Boyan.
Lordship, can the protection of service be, although I'm out of service, my lord.
As Mr.
Lordship,
was dropped, my lord.
You're out of service.
I'm out of service, my
No,
lord.
You'll see on the
It's difficult.
third MSB Boyan, Leonard Senior Counsel, assisted by MS.
RS Deuri.
RS Dury, Leonard Counsel for the petition. Issue notice. MS N. Tukan. The Standing Council Elementary Education Affairs for Respondents, 1, 2,
1 to
6.
1 to 6,
7,
7 and 8, my lord.
and 8.
I'm appearing for respond number 3, Lord.
Mr. R. Dar.
Respond number 3.
Standing Council, Accountant General Assam appears for respond number 3. Mr. A. Chalia, the Standing Council Finance appears for respond number 4. And G. Bekul, the Government Advocate appears for respond number
Nice to know.
5.
Nice to get a
Extra copies of the petition will be furnished. Petitioner takes steps for service of notice on respond number 9.
My lord.
I registered post AD within 1 week from today. List the matter after 4 weeks, prayer for entry shall be considered on the next.
My lord, SSA is a necessary party here.
Lordship, I'm sorry, I'll by hand, I'll insert it.
No,
my
no,
lord.
you can't.
Oh, now it is, it can't. be. Lordship, one aspect, may I?
Have to file an IS.
Lordship, I will. Lordship, what happened, my lord? They've taken a plea. I don't have the dice code. Which in not in my favor from 2000 after 2017, my lord, 2018. That's why in the amalgamated school I was not allowed to work. I have filed representation to issue dice in my favor before the, my lord, additional Deputy Commissioner Majuli. At least that may be considered, your lordship.
Which
Pays, my lord, 90 onwards.
how many representations have been made?
90 onwards, my lord.
No, which representation do you want?
Lordship regarding dice code, issuance of dice. That can be done, my lord.
No, application.
Tendency of this petition shall not be about on the respondents, particularly the assistant.
My lord.
To consider the representation made by the petitioner for issuance of dice.
Dice code, my lord. Right. Obliged. May I, lordship, get the date, my lord?
Date is
My
difficult.
lord.
So
Obliged.
20.
May I please, as a lordship? My lord, as per the 2010, the Assam College Employees Provincialization Rule, my lord. In the array of cadres, my lord, there is no provision for the post of vice principal, my lord. For a moment, my lord, I beg to draw my lordship's kind attention to the rule, my lord. At page 497, my lord.
yes.
Yes, my lord, in this rule, my lord, class and cadre, each college shall have a separate entry for the purpose of cadres of employees. All cadres and their classes in the Assam so and so will be same as in the government colleges. Strength of service, my lord. These are the service, my lord. Appointment to the post of principal shall be by of a direct recruitment. If we go, my lord, down below, the my lord, it will come down to the lecturer, librarian, and other, my lord, non-teaching category of post. But there is no provision, my lord, in this rule of 2010 that there can be a vice principal. Now, my lord, what has happened in this present institution, my lord may be pleased to find that the seniority list, my lord, is at page 36, annexure 9, my lord. Seniority list, my lord, myself is at serial number 3. My date of, my lord, joining is correctly shown, my lord, 19/9/1994. But this private respondent, my lord, who has given the charge of the vice principal, my lord, is at serial number 2. He has been shown as, my lord, on 2/8/1993. My lord, in fact, this is not correct, my lord. Why, my lord? I beg to draw my lordship's kind attention to one of the, my lord, concurrence order, my lord may be pleased to find. The permission order is at page 28, my lord. My assumption, no? My lord, this incumbent, the private respondent, Dr. So-and-so is an Arabic, my lord. Is an assistant professor in the Department of Arabic, my lord. Now, his permission, my lord, may be pleased to find at page 29. The permission to start the TDC first year class in Arabic and education and general course for the session 1997/98 is accorded. It should be, my lord, is accorded. So, my lord, for the first time in this college, my lord, this Arabic post has been introduced with the due permission from the authority from the year 1997 and 98. Now, my lord, he has been shown in this seniority list, my lord, has been appointed in the year 1993, which is not at all, my lord, possible, because this subject has got introduced in the college from the year, my lord, 1997 and 98 session only. Now, my lord, I was, my lord, existing in the college with the concurrence and everything was with the present petitioner, my lord. My lord may be pleased to find the present petitioner's appointment is at page 34, my lord. My lord, this is the appointment, my lord. May kindly note the date, my lord, 16/9/1994. I have the pleasure to inform you that have been appointed at Bhait the EC resolution number 5 as a lecturer of the Assamese in Suntoli Anshalik College. You are allowed to act as a lecturer of Assamese with immediate science. So, my lord, this is my appointment, and on the strength of this appointment, subsequently, my lord, I have also been provincialized also. Now, my lord, what has happened? There are some certain disputes are going on regarding the principalship in the state college. And therefore, my lord, as an interregnum arrangement, the higher education department has made an arrangement. My lord may be pleased to find that arrangement at page 37, my lord, Annex 10. My lord, this is an order in compliance of the Honorable Guwahati High Court order dated 24/1/2022 in WPC number so-and-so. The provincialization of the service order in respect of so-and-so, tutor principal, so-and-so college, so-and-so issued by this office order number so-and-so is kept in abeyance until further order. Now, we are concerned with the second part, my lord. The charge of principal and secretary of the governing body of the Suntoli Anshalik College, Mahatuli, Kamrup, is temporarily entrusted to the principal of JN College, Boku, Kamrup, in addition to his own duties to look after the normal day-to-day activities of the Suntoli Anshalik College, Mahatuli, Kamrup, until further order. Now, my lord, this power has been specifically entrusted by the director to the, my lord, principal of the JN College of Boko. Now, what this JN College principal has done, my lord, may kindly turn, my lord, to page 41, my lord. Vice principal যে লিখিছে যে কোনটো ভাইস প্রিন্সিপাল হিসেবে যে কাম কৰি আছে Yes, my lord, may kindly see the communication notice number 409, my lord, is at page 42, my lord. Lord, this is a communication of the college has been issued, my lord. This is for general information to the students of the BA so-and-so of the Anshalik College that the sessional examination will be conducted from 5/11/2022 to 10/11/2022 by the respective departments. The examination of the student having the honor subjects will be conducted on the question based in examination. My lord, may kindly say that this notice has been issued by the vice principal. And this vice principal has been made that the incumbent, my lord, which I have just, my lord, bring into my lordship's kind notice at, my lord, page number 36 is, my lord, Dr. Mubarak Ahmed has been given the charge of the vice principal, and he is entrusting the duty as a vice principal. Now, my lord, why we are agreed, my lord, with this vice principalship, my lord, as per the provision of the rule of 2010, there is no provision for the vice principal in a college, my lord. If it is required to be given, my lord, for some arrangement, my lord, the authority can do it, but not the principal of the JN College, my lord, who has been given the duty of the, my lord, in-charge principalship by the Director of Higher Education. That apart, my lord, the academic activities, if required to be, my lord, managed by the college authorities or by the college associate professors, my lord, then being the seniority position, I am entitled, my lord, not this person as a vice principal, my lord. So this arrangement is by the dehors of the provision of the rule, my lord. They cannot do this, my lord, because there is no cadre of vice principal, my lord. That's my limited submission, my lord. This, as this is not supported by rule, my lord, this vice principalship cannot be sustained, my lord. My lord may issue notice, my lord, and in the meantime, my lord, this vice principalship arrangement may be stayed, my lord. That is my limited prayer,
So coming too late,
my lord.
we are approaching late.
My lord, it is made on 2022. Till date, it is going on, my lord. Till date, the arrangement is going on. Yes, my lord, some delay is there. I have to admit fairly before my lordship, my lord. But as this is in violation of the law, my lord,
Yes.
my lord.
Lordship, notice only, Lordship, and one thing, Lordship, and you already silenced this interstate seniority, Lordship, page 38, Lordship. Already approved, Lordship, page 38. Another petition, Lordship, the petitioner, interstate is pending, Lordship. Relevant page 30, page 39. No, 90.
It took our আগৰ petition, no? It took 38 GB.
Already. Notice maybe you should take with this case, Lordship.
Yes, my lord, I have skipped this. I am seek apology for this, my lord. This is a petition filed by me, my lord, challenging the seniority list, which I have just brought into my lordship's. I notice that writ petition is also pending, my lord. No interim order has been given, my lord. But we are now basically agreed with this vice principalship order, my lord, because there is no provision of the rule that a vice principal can be appointed, my lord.
But yeah, we are not. Mr.
As we are, Lordship.
As Boyan, the standing council.
Hi, 1 and 2, Lordship.
Yes, for respondents, 1 and 2. Petitioner to take steps for certain of notice on respondents 3, 4, and 5 by registered post 80 within 1 week. Respondents are allowed to file.
Question of this, no, vice principal. My lord, may I pray
Please
for
allow
a-
me discuss, Lordship.
After 4 weeks,
Lord, the stay has been. My lord,
prayer for interim shall be considered on the next sitting.
returnable date.
Lordship,
My
please to along this case, Lordship.
lord, yes, my lord, it
List
should be
matter
listed
After 4 weeks.
along with
WBC
your
7203.
After 4 weeks, along with WBC number,
7203.
where is that order?
Is 38, Lordship.
38,
38.
WBC number 7203
2021.
2021.
Oblige me.
86 of supplementary list. Motion.
Wait, please, your lordship. Well, this matter has been placed before your lordship's bench one matter pursuant to office note dated 22/6. Before taking your lordship to the MP or not, my lord. May I indicate the relevant facts, members? There is a dispute between the parties which is going on from 2008, my lord. And for series of litigations have taken place between the parties, my lord, and 7 times the suit has been amended. And there is a direction by your lordships for day-to-day hearing of the case, my lords. That's why it's been progressing day-to-day basis, my lords. During the proceedings, my lord, when the PW1 was cross-examined, my lord, if your lordship kindly come to page 58 for a moment, my lord.
Yes.
My lord, during the cross-examination of PW1, my lord, the managing director.
Title suit.
Yes, title suit. But there was a complaint lodged orally by the managing director of the respondent plaintiff, my lord, before the court, pursuant to which, my lord, the then counsels engaged file a petition for withdrawal their name, my lord. And that was allowed. And new set of counsel was engaged on that day, my lord, and cross-examination took place. Now, if your lordship comes to page 59, my lord. This is the cross-examination which took place on 25, my lord, and at page 60, if your lordship kindly come.
Yes.
Line from 6 from above, my lord. The witness is, my lord has seen.
Yes.
The witness is shown certified copy of order dated so and so passed by the Honorable Guwahati High Court in WPC so and so. The certificate marked as Exhibit A. The plaintiff was a party in the suit. So, my lord, he was shown an exhibit, my lord. This exhibit was not part of the documents of the defendants, my lord. And my lord, the witness answered this, my lord. And thereafter, my lord, further cross was reserved for next date on 22nd, my lord. Thereafter, my lord, it was a cross-examination before the commissioner, advocate commissioner, my lord. And there, my lord, a report was filed, which your lordship signed at page 68.
Yes.
With reference to the above, I would like to inform you that, Your Honor, that the PW is cross-examined and further cross kept reserved as the witness could not produce original documents as asked for, submitted the and annexure, your lordship would see the defendant side exhibited one copy marked as Exhibit A. Now, my lord, that has already been, my lord, shown. And now, if your lordship would come to page 70, my lord, pursuant to the submission, my lord, the trial court passed this order on 20th of May. First order, my lord. Plaintiff is represented through a new set of engaged counsel by filing wakalatnama. Defendant were presented, seen petition filed by the earlier counsel. Withdraw their wakalatnama. Consider the aspect of the petition is allowed. PW is represent. And now your lordship would see further cross is reserved. Advocate commissioner has submitted the original copy of partly cross-examination. Till then, my lord, there was no dispute. So far as Exhibit A is concerned, my lord, that has already been exhibited. The commissioner report says so. The court also did not mark any objection. Now, my lord, on 22nd, my lord, if your lordship come to page 71, what happens, my lord, the earlier set of counsels, my lord, one of them is now being engaged. He comes into the scene, my lord, and during the cross-examination, he sees that Exhibit A has been marked the other day, and therefore a dispute is sought to be raised. My lord will see the second paragraph of page 71. During the course of cross-examination, the newly engaged counsel of the plaintiff, Sri so-and-so, requested the commissioner to put under objection Exhibit A, which was shown to the witness on 25/2023, to which counsel for the defendant objected. The counsel for the plaintiff submitted.
You're reading from?
My lord, at page 71, second paragraph. First paragraph is this is part of the cross-examination.
Yes, continue.
This is first para is the part of the cross, and second, what has happened, my lord. During the cross-examination of the newly engaged counsel of the plaintiff, so-and-so, requested the commissioner to put under objection Exhibit A, which was shown to the witness on 25/2023, to which the counsel for the defendant objected. The counsel for the plaintiff submitted, since the objection regarding Exhibit A is vital legal issue, further cross-examination cannot take place till the said issuance is decided by the court. So, my lord, the dispute was raised, and thereafter, my lord, now your lordship would come to page 74. The report was submitted by the commissioner. With reference to the above, I would like to inform you, Honor, in the so para 2 is important. During cross-examination, during the course of cross-examination, both the parties enter into a dispute regarding Exhibit A, which was exhibited on so-and-so, that one engaged counsel from the plaintiff side, so-and-so, raised objection regarding exhibited document. Now your lordship has seen who has raised objection in page 71, and my lord, your lordship has seen the name of the counsel in page 74. Now the issue was taken before the trial court, my lord, and my lord, when it was placed, an order has been passed, my lord, on 24/5. Now your lordship would kindly come to page 80.
Yes.
Order dated 24/5. Both sides are represented. peruse the report of the commissioner, and from where it is seen that there is a dispute arises between the parties regarding exhibit of a document as exhibit A by the defendant at the time of cross-examination of PW1. Today, learned counsel appearing on behalf of the plaintiff. Well, there was no petition file as such, no application there. It was all oral submission, and therefore this submission is very important, Lord. Today, learned counsel appearing on behalf of the plaintiff vehemently submitted before the court that no document can be exhibited from the defendant side during the cross-examination of a plaintiff witness. Per contra, learned counsel for the defendant submitted that the document can be exhibited during the time of cross-examination of a witness, even that document has not been enlisted in the list of documents with the WS. Considering the submission of both the sides, this court finds that a question regarding the aspect of exhibit of a document needs to be ascertained by this court on having a full-fledged hearing from both sides. And both the sides are directed to place the argument on so and so. The matter was argued, and subsequently, this order has been passed on 12/6/2023 at page 81.
What was the finding?
My lord, well, so far as the issue that has been raised, whether a document can be exhibited or not, my lord, we submitted before the trial court that as per the provision or order 7 rule 14(4), order 8 rule 1(4)(a), and order 13 rule 1(3)(a), it is permissible in law, that there is no dispute, and the trial court also come to a finding that it is permissible. The issue which was raised, it was decided in my favor. But additionally, my lord, the exhibit, now the trial court says that my lord, it would be marked under objection. Page 84, your lordship would see.
Yes.
The objection was read at the time of cross-examination of PW and further. But this is perverse, my lord.
Where is this? Where is this?
At page 84, my lord.
Para?
It's not paragraph, my lord. The first paragraph itself, my lord. I'll read, my lord. If your lordship permit, my lord, can I read the order from page 82 itself, my lord?
Is it necessary?
Not, my lord. 83, my lord, where the issue has been decided in my favor, it is admitted. Now in 83, my lord, now the question remains as to whether the objection raised by the learned counsel for the plaintiff during the time of marking of the said document to be as, well, this is perverse because your lordship has seen during the, when it was exhibited on 20th, there was no objection. Nothing was recorded. Had there been an objection, the trial could have been correct. Our case is, my lord, that on 20th, when this has been exhibited, there has to be an objection at that point of time. If it's not been raised at that point of time, you miss the bus. It cannot be raised subsequently, my lord. So, my lord, the trial court has exceeded its jurisdiction, my lord. And the apex court judgment is also clear. My lord, we place that judgment before the trial court, my lord. In para 20, if your lordship would kindly see.
Para?
My lord, I am placing the judgment of the apex court, my lord.
Yes.
At page 764, my lord.
Yes.
The learned counsel for the defendant respondent has relied on a Roman Catholic mission versus State of Madras in support of his submission that a document is not admissible in evidence, though brought on record, has to be excluded from consideration. We do not have any dispute with the proposition of law so laid down in the aforesaid case. However, the present one is a case which calls for the correct position of law being made precise. Ordinarily, an objection to the admissibility of evidence should be taken when it is tendered and not subsequently. The objection as to the admissibility of documents in evidence may be classified into two classes. Number one, an objection that the document which is sought to be proved is itself inadmissible in evidence. And number two, where the objection does not dispute the admissibility of the document in evidence, but it is directed towards the mode of proof, alleging the same to be irregular or inefficient. In the first case, merely because a document has been marked as an exhibit, an objection as to its admissibility is not excluded and is available to be raised even at the later stage or even in appeal or revision. In the later case, my lord, which is the objection should be taken when the evidence is tendered
And once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. The latter proposition is a rule of fair play. The crucial test is whether an objection, if taken at the appropriate point of time, would have enabled the party tendering the evidence to cure the defect and resort to such mode of proof as would be regular. The omission to object becomes fatal because by his failure, the party entitled to object allows the party tendering the evidence to act as an assumption that the opposite party is not serious about the mode of proof. So, my lord, this is a clear case, my lord. When, my lord, the objection was not raised, when the document was marked as exhibit, that is also reflected from the cross-examination, report of the commissioner and the order of the trial court on 20th. Now, subsequently, it can't be raised, my lord. And, my lord, in fact, this issue was also not raised before the trial court. Your lordship has seen. The issue was only raised whether it could be exhibited or not, my lord. And to that, the trial court is in my favor, my lord. This aspect, Lord, if this issue has been decided, where the question that it should be decided later on. And my lord has seen their own conduct. But if this issue is not decided, the trial court should not proceed with the cross-examination. So either your lordship decided today so that I can cross-examine the other part because it's been reserved, or my lord, immediately after reopening, Lord, your lordship can decide this issue since my learned friend is also appearing. And so that till then, Lord, that proceeding should be stayed.
First of all, after getting the name in the call list, I filed a Wakalatnama on behalf of the respondent. But till today, I have not received any copy of the petition to that effect. And made me a direction to furnish me the copy. So then I can go through it. And regarding this impugn order, this is only regarding an objection. So it can be raised or not. Then regarding a document filed by them when the cross-examination was done by our witnesses on behalf of. So your lordship, can you give a direction to give a punish? So on the Monday itself, it can be heard and it can be disposed of in the motion itself. Here. It is a very small issue here, lordship.
Well, since it's a civil dispute, my learned friend has appeared before the other court on 20th. He did not requested me, my lord. My lord knows only by filing Wakalatnama one doesn't get a right. He should have been filed a caveat, my lord. It's not been filed, my lord. Therefore, he does not even have a right to say. Anyway, my lord, I'll provide him a copy, my lord. Whenever your lordship pleases decide.
No
caveat has been filed, my lord.
Your lordship, to expedite the matter, I have appeared before the court.
But I am not there to my lord, teach someone, my lord, how to go about things, my lord.
Third, Mr.
R. Dubey, my lord.
R. Dubey, learned counsel for the petitioner. Stop. You are appearing for respondent.
Sole respondent, my lord.
Sole respondent, notice. Mr. P. Chowdhury. P. Chowdhury, learned counsel. And train also. And Kolita. And Kolita. And N. Kolita, learned counsel, enters appearance on behalf of the sole respondent by filing Wakalatnama. Stop. Learned counsel for the petitioner is directed to furnish a copy of this petition. To the
Or my lord may issue notice, my lord, so that since he is appearing, I'll furnish.
No need to issue notice. Issue notice. I've issued notice, you finish.
Yes.
Finish the matter. Again on when?
Subject to convenience, my lord. If your lordship can take it up since
next week will be difficult.
Let it come immediately after vacation, my lord.
After the winter, summer vacation.
Only, my lord, till then, my lord, the further proceedings should be stayed, my lord.
Yes, your lordship. Till the next. It was fixed today also in the civil court. They have taken adjournment, your lordship. So that doesn't need that they want to stay for that.
Title
suit number
221 of 2008.
1 minute. Title suit number 221 of 2008. Before the civil judge number 1, wooden bracket K. Guwahati shall remain suspended.
Deeply over. My lord, please, we can't fix date, my lord.
I can give a.
My lord, deeply over.
21 of daily list, admission.
My lord, on the last occasion, my lord, Lordship was directed to take instruction by the department, my lord.
Yes, Furkan. What matter was this?
My lord, the petitioner was, my lord, founder teacher of a school, my lord, and my lord, he was expecting his service to be provincialized, my lord. But when the provincialization was done, my lord, his name was not included, and my lord, in his place, a junior was provincialized. And my lord, when he inquired, my lord, it was told, my lord, that he has been terminated from service long back, at least 5-6 years back from the date of provincialization, which he was behind his back. And my lord, it is there in affidavit position that he was not served any notice before his, my lord, termination. That is my case, my lord.
May I please your lordship? Lordship, the petitioner was appointed by the managing committee and terminated by the managing committee. And before provincialization, managing committee is the main part of a school, my lord. As per 2006, my lord.
Who appears for the managing committee? Anyway, Furkan, you can continue.
Fine. As per 2006, my lord. 2006 Act. Page 572, my lord. Section 12. Constitution of Managing Committee. Every non-governmental 587 page.
Yes.
Every non-governmental educational institution shall constitute a managing committee consisting of the following, namely the chairman of the president or the principal managing agent of the society or trust, or the occasion of individuals or the persons or individual establishing the non-governmental educational institution shall be the chairman of the managing committee. Chairman, the headmaster, the principal of the institution, as the case may be. And my lord, kindly see page 488, my lord. Section 13.
488.
588, sorry. Powers and function of the managing committee. The managing committee shall have control over the appointment of the employees, disciplinary action against the employees, and the overall administrative control of the affairs of the institution. The managing committee shall not conduct the affairs of the institution in such a way which may adversely affect the interests of the institution. And my lord, kindly see now section 15, my lord, 589 page. Appointment and disciplinary matters. The school authority shall issue appointment letter in the event of any appointment made to any person in regard to its affairs, and such appointment letter shall clearly state the terms of appointment, salary, and any other conditions of service in respect of such appointment as per scheme of management of the institution. No employee of a non-governmental educational institution shall be dismissed, removed, or reduced in rank or terminated without giving him a reasonable opportunity of being heard and without the matter being referred to the managing committee for its consideration and approval, provided the school authority may suspend an employee with immediate effect without the prior approval of the managing committee if it is satisfied that such immediate suspension is necessary by reasons of his gross misconduct under the code of conduct framed under the section 16. My lord, the petitioner was removed from this school only because of unauthorized absence, my lord. My lord.
Was he given an opportunity of hearing?
Yes, my lord. His service was terminated in the year 2006, and he approached before this honorable court in the year 2015. and the school was provincialized in the year 2013. My lord, it is not a case for delay and laces, my lord. I have a one citation, my lord.
Was provincialized on
2013, my lord.
when did you approach this court?
In the year 2015, my lord, sorry. And my lord, before provincialization, the school managing committee is the main part of a main part of a school, my lord. Is the main appointing authority, my lord.
Yes.
And my lord, this is one also a judgment, my lord, Abdul Ghaffar Mandal case, my lord. Regarding the educational tribunal, my lord. I think he should go for a tribunal. Go before the tribunal.
Yes. Para?
And my lord, and this is the notification.
Where's this, what does this judgment say? This full bench?
Yes, my lord. For the non-governmental educational institution, my lord.
Which paragraph?
They may approve before the
Which paragraph?
tribunal, my lord. I have to,
You have a copy only.
my lord. Yeah, para 26, 27, 34, 37, 45 and 45, 46 and 48, my lord. My lord, kindly see para 48. In view of the above, we issue a writ of mandamus to the state government to establish a educational tribunal at the district to adjudicate disputes relating to the teaching and non-teaching staff of the non-governmental educational institution, as well as disputes concerning disciplinary action and claim for provincialization in respect of teaching and non-teaching staff of venture educational institution. Till the establishment of tribunal, the state government shall, within a period of 4 months, the consultation with the High Court designate the district courts as the education tribunal of the respective districts.
Yes.
My lord, this judgment is regarding my lord non-governmental educational institution, my lord. This school is, my lord, no more a non-governmental educational institution, my lord. It has been provincialized, my lord. Now it is, my lord, fully government school, my lord. Number one. And my lord, here, my lord, judgment of this honorable court as well as Supreme Court, my lord. When, my lord, a case which, my lord, dealt by High Court for a long time, my lord. My lord, it's, my lord, almost, my lord, 8 years, my lord. pending in this court, my lord. At this point of time, it is not proper to send it back to the tribunal, my lord, because, my lord,
Is it a government school now?
Yes.
Provincialized school.
School was provincialized in the year 2013. He was terminated in the year 2006, my lord,
well,
by the managing committee, my lord. When the incident was occurred at the stage when the school was in the venture stage, my lord. Now we
So
cannot
when
do
the
anything, my
school
lord.
was provincialized,
Yes, ma'am.
he was no more in the school.
Yes, ma'am. He was not a teacher at the time, my lord, because he was terminated in the year 2006 by the managing committee. Managing committee is the,
Is that correct?
my lord,
Yes, my lord.
my lord, probably my friend has not gone through the writ petition, my lord. The fact, my lord, I am explaining, my lord. My lord, I was the founder teacher of that school, my lord, and my lord, when my lord, this process of provincialization was going on, my lord, my name was first not sent, my lord. When provincialization in the year 2012, my lord. My lord, I was before the, my lord, I have made representation before the department, my lord, and my lord, they have not made any, my lord, inquiry, or my lord, they have, my lord, give any answer to my representation, my lord. Thereafter, my lord, I have filed an RTI, my lord. That was also ignored, my lord. Thereafter, my lord, I approached the director, my lord. And before the director, my lord, when the, my lord, director has compelled the block elementary education and the my lord, district elementary education to come before him, my lord. Then only, my lord, there is a letter to that effect, my lord. When, my lord, it was informed to me, my lord, that I was, my lord, I was running from pillar to post, my lord, for my provincialization, my lord. And my lord, I was only informed in 2013 that my service was, my lord, terminated in 2006, my lord. My lord, that is from record, my lord. I'll show it to your lordship, my lord. And it was also, my lord, they have admitted that there is no notice given, my lord, to the petitioner, my lord. Everything has been done behind the back, and only to, my lord, to my lord, to give the benefit to the private respondent. These are all done, my lord, on the behest of the private respondent as well as the principal of this school, my lord. My lord, lordship will see, my lord, the provincialization list, my lord. All the teachers are, my lord, appointed in 1986, my lord. And I was also appointed in 1986. Only he is appointed in 1989, my lord, the private respondent, my lord. All other teachers are appointed in 1986, my lord. And the school was established in 1983, in 86, my lord, around 1986, my lord. And when my lord, all the teachers was appointed, I was also appointed, my lord. But my name was not sent for provincialization, my lord.
Because you were terminated.
My lord, not terminated, my lord. My lord, I'll show from the my lord, annexers, my lord.
Just now you said that you were terminated in 2006, which came to your notice in 2000.
Yes, my lord, my lord, kindly see, my lord, the provisions for provincialization, my lord. I'll show, my lord, the provisions for.
Here is managing committee and the headmaster.
My lord, let us finish, my lord. Okay, you finish first, then I'll complete.
Yes.
My lord, the process for provincialization, my lord, how a school is, my lord, a school is provincialized, my lord. There is a provision, my lord. They all are given in this act, my lord. Now, my lord, the names, how the names should be sent, my lord. And my lord, when, my lord, the school was recognized, my lord, the private respondent was not there, my lord. And due for recognition, my lord, the names of the teachers are required to be sent to the education department, my lord. When, my lord, my name was sent, my lord, I'll show from my lord, from the annexers, my lord. Annexer 1, page 31, my lord. Lordship may kindly see. Type copy as page 26, my lord. Page 26, my lord.
Yes.
My lord, Government of Assam, Office of the District Elementary Education Officer, Barpeta inspection report. This is an inspection report, my lord. Now, my lord, this inspection report is of, my lord, 24/8/1990, my lord. My lord, this report was sent when, my lord, recognizing the school, my lord. Now, my lord, lordship will find my name at page 28. Lordship has got it, page 28, my lord. Description of teachers. My lord, I have given the original copy of which is in vernacular, my lord. Sri Gaurikanta Kolita, head teacher, my lord. Headmaster. Second, my lord, Balaram Das, assistant teacher. Dhaneswar Thakuria, Korun Kolita, Madan Talukdar, my lord. This is the petitioner, my lord. Date of appointment, lordship will find 3/4/1986. Now I'll show your lordship from the rule, my lord. What my lord, procedure to be followed for my lord recognition of the school, my lord. My lord, may kindly see the Assam Non-Governmental Education Institution Regulation and Management Act, my lord, 2007. My lord, I am taking one whole, my lord, book, my lord, in new page. My lord, the Assam Non-Governmental Education and Institution Regulation and Management Act 2006. In my book, my lord, this is in page 370, my lord.
Two 2006.
Yes, my lord. Thank you. My lord,
Yes,
my lord,
page 573.
yes, my lord. Now, my lord, section 4, my lord. Section 4, my lord. Section 4, my lord, may I read, my lord? Any individual, association, individual, non-governmental organization, society or trust intending to establish and run non-government educational institution and on giving an undertaking to fulfill the requirement as laid down under section 10 may submit an application before the director in such form containing in such particular and information as may be prescribed for obtaining prior permission for establishment and running of such institution. My lord, thereafter, my lord, administrative recognition, my lord, 5, my lord. Section 5, my lord. After establishment and registration of non-governmental education institution under subsection 5 of section 5 of section 4, the authority shall make an application on payment of such fees and from manner as may be prescribed before the day for obtaining administrative recognition in respect of the institution, my lord. For this, my lord, there is an inspection done by the authority, my lord. My lord, the rule also says so, my lord. This is the act, my lord. The rules are, my lord, here, my lord. Assam Non-Governmental Education Institution Regulation and Management Rule, my lord. Rule 5, my lord.
Where's the rule?
Rule, my lord. The next is the rule, my lord. Immediately after the act, my lord, the rule, my lord, is there. Assam Non-Governmental Education Institution Regulation and Management Rule 2007. My lord, Rule 6, my lord. And Rule 6, lordship may kindly see.
Yes.
Inquiry or inspection for recognition and administration recognition of existing institution, my lord. So, my lord, inspection is required, my lord. And this is the inspection report I have produced, my lord, which is of my lord. The original copy is also there, my lord, which is of my lord, of the year, my lord, 1990, my lord. Case 26, my lord, where my name is existing. So, my lord, an inspection was done, and only after that, thereafter, my lord, a school, after establishment, my lord, the recognition is required, my lord, administrative recognition, my lord. My lord, when my lord, it is given by the department, my lord. Only after an inspection,
The
my lord.
issue is this. There's no dispute that your school was recognized.
My lord.
Correct.
Yes.
When your school was recognized, you were there.
My lord,
Respondent 11 also was serving.
my lord,
You were appointed in 1986, respondent 11 in 1990.
my lord,
But then in 2006, you were terminated,
my lord,
correct?
my lord.
After that, a new chapter starts.
No, my lord. My lord, the crux is there, my lord. The thing is this, my lord. My lord, when my lord, the process for provincialization was going on, my lord, my name was not sent, my lord.
That was in which year?
My lord, in 2012, my lord. Now, my lord, why, my lord? I'll explain to your lordship, my lord. Then, my lord, I wrote to the my lord, to the department, my lord, regarding my lord non-inclusion of my name, my lord. They have not replied, my lord. My lord, thereafter, my lord, they were, my lord, I preferred an RTI, my lord. An inquiry was conducted, my lord. Lordship may kindly see the inquiry report. When, my lord, it was disclosed to me, my lord. My lord, if it would have been a case that in 2006 itself, my lord, I was aware of my dismissal from service, my lord, I could have come here, my lord. But they have not, my lord, disclosed this to me, my lord. And only when they were compelled to come before the director, my lord, and director conducted an inquiry, my lord, they disclosed that I was terminated in 2006. And my lord, what report they have given, my lord, that I was appointed, my lord, initially appointed in 1990, and he is senior to me, my lord.
Let us see the report. Page 50.
My lord, my lord, page 56, my lord, annexure 13.
Incomplete page.
My lord, subject from MC Deccan, the district elementary education officer to director of elementary education. Subject RTI petition of Sri Madan Talukdar and submission of report thereof. Sir, with reference to the subject and the letter number cited above, I have the honor to submit here with the detailed report in respect of the grievance of Sri Madan Talukdar for non-provincialization of his service against Nalbari ME School under Bozali Education Block as under. That a hearing was conducted in this regard in presence of a headmaster SMC president of the school and Sri Madan Talukdar on 4/9/2014. My lord, now the hearing was taken place in 2014 only, my lord. That as per hearing and the statement and other related documents submitted by headmaster of the Nalbari ME School, it has been found that Sri Madan Talukdar was appointed in school in 1990. And accordingly, he joined in school 3/3/1990. That as per inquiry report of BO Bozali, it is found that Madan Talukdar was unauthorized absent in school with effect from January 2006 till the date, the inquiry date, that is 15/3/2013. As a result, which Sri Madan Talukdar was discharged from his duties by the SMC as per resolution number 1 of the executive committee meeting of SMC held on 17/8/2006. But in this regard, no notice was issued to Madan Talukdar. So as I was not aware of this fact, my lord. And my lord, it is done on the behest of the private respondent so that he can be accommodated in service, my lord.
See page 51.
We'll continue at 2. Not. We'll take up this matter after some time.
My lord.
After the vacation.
My lord. My lord.
What, Mr.
Z Goswami, man. V Goswami, man.
What's your level
Z Goswami, my lord. Z Goswami.
Elementary.
And for respondent number 9, A Gogoi. Respondent number 9, A Gogoi.
And for respondent number 11, M is come.
22.
My lord, a date can be, my lord, may pray for a date, my lord.
Okay. Yes, please.
May it please your lordship. Lordship, this petition is filed by the petitioner for selection appointment for the post of librarian. The last date the respondents were to seek instruction, lordship.
Have you received instructions?
No, lordship, here, lordship, the private respondent had filed, and lordship, I can period the affidavit filed by the private respondent number 5, lordship. The, there, the private respondent has annex 1, annex 5. On the date of interview, the petitioner has been absent from the, on the date of interview, lordship. She didn't appear in the interview itself.
Annexure?
Annex 5, the affidavit portion filed by the respondent 5, lordship. Page 11.
Who is the
CL
petitioner?
number 18. Lordship, CL number 18, applicant number 33, Nazima Khatun, absent, lordship. Then how we can claim this in this representation? Then nothing remains, lordship.
Lordship, we will file our affidavit, reply, lordship.
And
What reply to you?
and it was filed in the year 18, and till date they have not rebut this allegation. Lordship, may kindly dismiss this petition, lordship. There's nothing.
Yes.
Yes. Then
Let my senior be heard then, once.
when she didn't appear in the interview, how you can claim the relief, lordship?
She's not confident.
After vacation, lordship.
On request made on behalf of, who's your senior?
Mr. S.C. Vishwas.
SCB Swas Leonard, counsel for petitioner, list after some of this.
24, 23.
Lordship, petitioner service was terminated long back. Thereafter, Lordship, their termination was set aside by this honorable court. Writ appeal filed, writ appeal dismissed. Thereafter, Lordship, petitioner has been restored to service and the consequential benefit was released. Some amount was not paid. Lordship, they have deducted twice. Thereafter, Lordship, petitioner has filed representation that that cannot be deducted. And ultimately, this court has on last occasion on 10/4/2023. 10/4/2023. Para 6, respondent in the elementary education department, finance department shall take notice that in the event no affidavit is filed within time allowed, court shall invoke the doctrine of non-traverse and it will be deemed that the respondent has admitted the claim and petitioner accordingly an admission. The petition shall be disposed on next day. Respondent in the elementary education department, finance department also put to notice that as the Secretary Government of Assam, elementary education department has issued sanction order on Iman, yet full disbursement was not made. Said authority shall also be liable to interest of 9% on the balance amount wrongly deducted towards professional tax and other like GST, GPF, etc. In this regard, it is provided that the respondent desire to escape payment of interest, it would be open to authorities to consider release of the balance amount of the petitioner prior to the next date listing. So small amount, only 79,000 was deducted wrongly, Lordship, after long persuasion, and that amount is still due. Small amount, but I have to appear.
They have not released the amount.
No, not really, still there. This is the consequence of the first petition.
Instruction received, my lord. Government has sanctioned amount of 84,162. Only to in connection with, accordingly, this office has allotted budget amounting amount for transaction and 100 and only to DDC cum BO, the Borpeta block through hotel, my lord.
Lordship may post this matter after vacation. Let them give the copy of the sanction order now. They have said if sanction now.
Yes.
On request made by Mr. S.K. Goswami.
No, Lordship, because money has not been released.
Oh, you have not.
Deposited in the concerned
On request made by Mr. G. Vibul and the running council.
Elementary
education is up to somebody.
Let them give the copy, Lordship, the sanction letter. Lordship.
Produce a copy.
24.
In this letter, number of times the petitioners were accepted. Number of applicants.
Last order, maybe Perusca.
I think this morning there was a prayer for adjournment of this matter.
Then, maybe.
None appears for the petitioner. Mr. A.R. Davildar, then the standing council,
Higher Education Department.
Higher Education Department is present. Also-
4 and 5.
Also heard Mr.
Yes, you're right.
Correspondent 4 and 5 and Mr.
For respond number 6, my. Governing body.
List of the summer vacation.
25.
Here, my lord, we have received a instruction, my lord. All the petitioners were approved by GOV for recommendation. Accordingly, 11 also have joined their service, my lord, but 6 were not joined.
Where is the instruction?
Yes, my lord, on top of the matter.
Lordship, there was a speaking direction to file affidavit, Lord. That was.
There was a, yes, on 35/2023.
That instruction I have.
Heard Mr.
L. Mohan.
L. Mohan, then the council for petitioner, Mr. J. Dipul, the next. Standing council elementary education submits that he has received instructions and prays for 2 weeks' time to file affidavit in others.
26.
May it pleases your lordship. Lordship, matter pertains to change of name of the petitioner, lordship. She is an Arunachal Pradesh Civil Service 2016 batch officer, lordship. And she had completed her in the year 2001 and class 12 in the year 2003 from Vivekananda Kendriya Vidyalaya, Tezu, Arunachal Pradesh, and it was under CBSE, lords. And thereafter on 27/9/2016, by swearing an affidavit, she had changed her name from Manisha Patin to Uni Patin. And thereafter she approached the Chief Secretary to the government of Arunachal Pradesh to record her change her name, and accordingly it was recorded, and the governor of Arunachal Pradesh was pleased to allow her change of name. And to that effect, it was published in the official gazette of the Arunachal Pradesh by order dated 30/11/2016. We have annexed it, lordship. It is in
Page 13.
Annexure 5, page number 13, lordship.
Yes.
And thereafter, she approached the respondent authority, that is CBSE, to correct her name in her class 10th and class 12 certificate issued by CBSE. And her prayer was rejected on the pretext of some bylaws issued by the CBSE. And for that, lordship, she had approached this honorable court. And I want to place one judgment of the Honorable Supreme Court of India, lordship. And I think petitioner case is covered under this judgment. I want to place it, lordship. Citation is lordship 2021-7 SCC 535. Relevant paras are lordship at,
That's 194.
yes, lordship, page number 610, lordship. Here in this judgment, certain directions are given to CBSE, lordship. May I read the relevant portion, lordship?
Yes.
Yes, lordship, para 192. Although we have discussed the broad issues canvas before us, in the ultimate analysis, the real dispute requiring resolution is about the nature of correction or change, as the case may be permissible to be carried by the CBSE at the instance of the student, including past student. As noted earlier, broadly, two situations would arise. The first is where the incumbent wants correction in the certificate issued by the CBSE to be made consistent with the particulars mentioned in the school records. As we have held, there is no reason for the CBSE to turn down such request or attach any precondition except reasonable period of limitation, and keeping in mind the period of which the CBSE has to maintain its record under the extant regulations. While doing so, it can certainly insist for compliance of other conditions by the incumbent, such as to file sworn affidavit, making necessary declaration and to indemnify the CBSE from any claim against it by third party because of such correction. The CBSE would be justified in insisting for surrender or return of the original certificate issued by it for replacing it with fresh certificate to be issued after carrying out necessary corrections with caption or connotation against the changes carried out and the date of such correction. It may retain the original entries as it accepts in respect of correction of name affected in exercise of right to be forgotten. The phrase certificate may also contain disclaimer that the CBSE cannot be held responsible for the genuineness of the school records produced by the incumbent in support of the request to record correction in the original CBSE certificate. The CBSE can also insist for reasonable prescribed fees to be paid by the incumbent in lieu of administrative expenses for issuing phrase certificate. At the same time, the CBSE cannot impose precondition of applying for correction consistent with the school records only before publication of results. Such a condition, as we have held, would be unreasonable and excessive. We repeat that if the application of recording correction is based on the school records as it obtained at the time of publication of result and issue of certificate by the CBSE, it will be open to CBSE to provide for reasonable limitation period within which the application for recording correction in certificate issued by it may be entertained by it. However, if the request for recording change is based on change school records post the publication of results and issue of certificate by the CBSE, the candidate would be entitled to apply for recording such a change within the reasonable limitation period prescribed by the CBSE. In this situation, the candidate cannot claim that she had no knowledge about the change recorded in the school records because such a change would occur obviously at her instance. If she makes such application for correction of the school records, she is expected to apply to the CBSE immediately after the school records are modified, and which ought to be done within a reasonable time. Indeed, it would be open to the CBSE to reject the Lordship.
Yes,
What happened in this case, he has passed out in the year 2003, higher secondary.
limitation period is 10 years.
Limitation earlier 5 years. So at that time, limitation period was 5 years. So her petition, her application was not considered, Lordship. Because at the gap of, in the year 2016, Lordship, she has made an application before the CBS. 2016. Lordship, in her application,
Who is the application?
in her writ petition,
Application is
page
not.
annexure 6, Lordship, page 14. The school has that school has written to the has certificate has given and annexure
No,
7.
but where's your application?
Application has not been annexed here, Lordship. The
Application
communication
fee has
which
not
we have
annexed,
received
Lordship.
from the CBSE that has been annexed. It is in page number 7, Lordship.
Only the rejection letter in 2018.
The application was made through email, Lordship.
And that letter was submitted on 10/7.
Where's the rejection?
2018.
Rejection?
Rejection is page number 15, Lordship, annexure 7.
Dear Lordship, she has later given a letter endorsement through email dated 10/7/2018. At that time, Lordship, limitation period was there. So after a long gap, Lordship, she has submitted the application for correction of, not correction, change of name. Earlier, she was known as a different name,
Yes.
Manisha Patil. Now she wants to change her name as Une Patil.
She has changed it.
Yes, Lordship.
Changed, Lordship,
By
already
exercising her right
changed.
of
As per the Honorable Supreme Court direction, Lordship, now this Lordship can direct or to actually whether it tell you with the public documents.
Yeah, where are your public documents?
Lordship, public documents, it is in para number 194 of 4.2 of this judgment, Lordship may see, here
Aadhaar
it
card-
has been clearly reflected that where the change is to be effected on the basis of new acquired name without any supporting school record or public document, that request may be entertained upon insisting for prior permission or declaration by a court of law in that regard and publication in the official gazette. So Lordship, publication in the official gazette is already there, and if your Lordship directs, then it may be done, Lordship.
Paragraph 194, Lordship, this is as regards request for change of particulars in the certificate issued by the CBSE, it presupposes that the particulars intended to be recorded in the CBSE certificate are not consistent with the local school record. Such a request can be made in two different situations. The first is on the basis of the public documents. So we always make the correction or change with regard to the relying on the public documents like birth
This is the issue.
certificate,
Where are your
Aadhaar
public
card.
documents? Aadhaar card, PAN card.
PAN card, Lordship.
Petitioner
election
can
card.
submit it, Lordship, along
You
with
have it with the new name.
as of now, I don't have it.
No,
You
that-
have it with the new name.
That I have
Maybe
to
Lordship.
repeat it.
But
That
it
you
should
can,
be the
that
early-
you, that you check up. If you have your Aadhaar
Yes.
card and the PAN card with the new name,
Yes, yes,
then
Lordship.
after this court will direct in terms of the public documents.
Yes, Lordship.
Lordship, I will obtain instruction. Lordship may fix a date for that, and on that very date, I will produce it, Lordship.
Okay. On request made by MS,
B. Devi, Lordship, on behalf of Mr. S.P. Chaudhary.
D. David and council on behalf of SP Chowdhury, list the matter after the summer vacation. Meantime, you collect the
Lordship. Obliged.
Obliged.
May I please the lordship? In this case, lordship, the presenter complete lordship may kindly fix the case for hearing.
My lord, the pleadings,
After the vacation.
pleadings are complete. He is continuing to hold the post. The only point to be considered is, my lord, I know it's before vacations, my lord, I should not be. But the only point to be considered is whether my B.Ed degree is proper or not, my lord. It's a big file, but my lord did not go into that.
Also heard before.
And my lord had heard this matter also, my lord, earlier. The notes may be there, my lord.
The notes are not there.
Oh,
Anyway,
your lordship.
what is your difficulty today?
We have 7 affidavits following, and we also have to do the running test presentation of that. We are still to done. Lordship.
The running test.
We'll find it difficult to assist your lordship. Presentation also we need to do it. For a full.
Okay. We'll keep it in the admission stage only.
Yeah.
No need to fix it for hearing. But you can hire a senior counsel assisted by Mr.
D. Deka.
Also had Mr. SMT still understanding counsel, secondary education, Mr. Ayalam for understanding counsel NCP.
Thursday by very close. And no adjournment.
On request made by Mr.
SK Das.
SK
For
Das.
respondent for 7.
There is also for respond number
7.
7, list up to the summer vacation.
My lord, can it be, if not others, inconvenient on 20th, my lord?
20.
20. Subject to my lord's.
Lordship may kindly fix it in the first week of August.
No, my lord, we'll have it because of some urgency is there. Lordship. Good.
Mr.
My lord, my friend will have some difficulty, my lord, on 20th. Is some
In
medical
the first week
problem.
of August, Lordship may kindly.
My lord will have it on the first, my lord, if not. on the-
First.
Tuesday, yes.
It's a Tuesday, man.
Yes.
Much obliged.
First.
Obliged.
28 and production list 1.
The last one is not coming. What happened?
My lord.
What happened to your application, Doctor?
Lordship, application is already there, Lordship.
No, I'm asking Mr.
It's I'm told it's coming. Sorry.
Yes, where's your IA?
IA Lordship,
two IAs are there, Lordship. One is for
Which is the one you filed recently?
recent
1822.
1822 is the for impleading party and challenging notification, Lordship. 1767, Lordship.
1822 is what?
For as per direction, Lordship, this honorable court, Lordship, I implead the Srimanta Shankardev, Lordship, University as a party respondent number 4, Lordship. I pray for impleadment. Before
Yeah,
that,
Gogoi,
Lordship,
any objection?
Well, see, regarding implement, my lord, I have nothing to say, man.
Heard Mr. K. Majumdar and the council of the applicant. Also heard Mr. B. Gogoi and standing council. Health Department. For the respondent number, for the opposite party number
4, Lordship.
3.
Sorry.
By this application, applicant is praying for impleting the Srimanta Shankardev University of Health Science, comma, represented by register, comma.
Well, I can accept notice, man.
You are accepting notice?
Yes.
Okay. The comma, by register, comma, the Srimanta Shankardev University of Health Science, Narkasur Hilltop, Bangalore, Guwahati 32, Kamrup, within bracket M, Assam, as party respond number 4. In WBC number 4278 of 2020, correct?
Lordship, 4278 of Lordship, 2021, Lordship.
4278 of 2021.
As well as in the IA, Lordship, 1767, Lordship.
You've met this application only for.
No, Lordship, my prayer is also there, Lordship. IA civil number as well as IA civil number
Corrected
1767.
in the writ petition, my lord, only then it can be corrected in the IA. Cannot be on the same day.
Automatically it will come.
After hearing the learned counsel for the applicant, prayer for implement is allowed.
And
I is disposed.
regarding Lordship, 176.
1 minute, WBC number 4278. In view of the order passed today in I number so and so. Let so and so be impleted as party respond number 4 in the present writ petition. So. As Mr. B. Gogoi, Learned Standing Council Health Department. Accepts notice on the newly impleted respond number 4, no formal steps are required. You want to file some affidavit? or-
Yes, we'll file a.
So, Mr. B. Gogoi, Learned Council for the newly impleted respond number 4, prays for how much time?
Well, immediately after the vacation.
Prays for 3 weeks time.
3 weeks.
To file affidavit, prays allowed, list after the summer vacation.
Lordship. I have a prayer, Lordship, in regarding IA 1767, Lordship. Because, Lordship, this institution is regarding the affiliation by Assam Science and Technology University, Lordship.
When was this filed?
It was filed on 19/6/2023, Lordship.
My lord, my humble submission, my lord, after this particular notification dated, my lord, 6/6/2023, the present writ petition has become infractor. By this notification, Lordship may kindly turn to page 40.
Lordship.
IML.
During the pendants,
Challenge it in a press writ petition, my lord, this is a press
Lordship.
cause of action.
may I pray, Lordship?
1 minute. Yes.
Lordship. In main writ petition 8/6/2023, there was an order from this honorable court for taking instruction about the Assam Science and Technology University and Srimanta Shankardev University, Lordship. In the meantime, Lordship, they have issued that notification, which is in continuity of the process of the writ petition, Lordship, because my affiliation is pending before the Assam Science and Technology University, Lordship. And only on the question of NOC from the government, that point was earlier, I was hesitating, Lordship. And in this notification, which is a complete violation of Article 254 and Union list 66 as well as 25 of the concurrent list, Lordship. I have stated in my Lordship, and I will also rely on some judgment on that aspect, Lordship.
Yes,
My lord.
what do you say, Gogo here?
Yes, regarding this, my lord.
You want to file an objection?
Yeah, of course, my lord. On the maintainability of this particular IA, my lord, considering the prayer made, my lord, he has
Third,
prayed.
Mr. K. Majumdar, then
That will be after vacation in that way.
issue notice. Mr. B. Gogol, who appears for the PCI? Mr. Reach so and so, the council appears for the opposite party number one. Respond number one. Assam Science and Technology and Mr. SP Chowdhury. That's what. For the respond number two. Mr. B. Google, Council, Standing Council Health Department appearing for respond number three. Raised for how much time?
Immediately after vacation.
Lordship, on the same day, Lordship, because
Raised for 3 weeks time.
it's a very urgent, but Lordship,
To
because
file
affiliation
objection.
question is there, Lordship.
Praise allowed list after the summer vacation.
Any, I pray, Lordship, any
You
day,
can
Lordship.
make your mention after the summer vacation.
My oblige.
Just 30 months, May the matter relates to my provincial prosecutor, assistant royal lordship directed them to bring some instruction, my lord.
Yes, Lordship. Lordship, immediately in terms of your Lordship, direction, Lordship, I have written data and.
Is it with regard to provincialization?
Yes, my lord.
Yes, Lord.
Because they are, some data were given by the.
Then how about the special division bench?
No, Lordship, this is not that.
This is not.
Lordship, one time may be granted, Lordship, obtain the instruction.
Did you get the instructions from the Guwahati University?
No, Lordship, a recent letter, Lordship, it's on it of June, Lordship, so I have not received yet.
They have filed affidavit, Guwahati University has filed affidavit.
No, they've sent a clarification letter.
My lord.
After 1 week, maybe, Lordship, I'd come with the instruction.
Let him take this. But Mr. S. Mukhtar and the council.
But their instruction will be better if it comes, my lord.
Mr. Tamildar and the Standing Council Higher Education. Prays for another 1 week time to enable him to receive instructions.
Can it be on 30, my lord?
Is the matter on 30 will be difficult after the summer vacation.
A date may be, other is not come, a date may be. Anyway,
You can make your mention, I'm not giving dates.
my lord.
Oblige, Lordship.
Item 2 of production list. Mrs. Gornali Tetia versus Women of India.
My lord, the other day, your lordship passed an order saying the operation of NIT, which your lordship will find at page 14. Order dated 16/6/2023.
In the IA.
IA, my lord.
Yes.
Your lordship may look at page 15, the operative part. At page 15. In the last para, my lord, in the interim, the notice inviting tender dated so and so issued by the Brahmaputra Valley Fertilizer Corporation Limited shall remain suspended
with regard to serial number so and so, so and so. Now, the fallout of this case, your lordship will find at page 17. There is an retaliation. My lord, the order dated 21/6/2023. Consequent upon selection through department interview come assessment, Sri so and so has been transferred and posted as vice principal at so and so school. He will be entrusted the responsibility for all intended purpose of school. Mrs. Bernali Chetia, my lord, she is the petitioner here. Ad hoc teacher cum demonstrator is hereby requested to hand over the responsibility entrusted to her. While letter number so and so, dated so and so to Sri Dhrubajiti Charangia along with files. Now, since my lord, she came before this honorable court and gotten orders for staying the NIT, my lord, on a retaliation basis, they passed this order and they have ousted me from this post. And now even they are threatening, my lord, they will ask from the service as well as from the quarter where I am living now. Now, this is the threat perception I am having. So, my lord, may I pray that this order is required to be stayed in the sense, my lord, it is passed in a punitive basis. Because it's not very innocuous, as your lordship has seen. They have said departmental interview.
Anybody appearing for the other side? No.
We served a copy to Mr. Gogoi and I requested him also to be here. But I don't know why he is not appearing.
Gogoi, K Gogoi.
K. Gogoi.
Maybe he has nothing more, nothing much to say in this.
It seems. My lord.
How many IS did you file? How many IS you filed?
This is the IA we filed today, 1829, my lord. 1829 of 2023.
Okay, okay. But Mr. S. Datta, Leonard Senior Counsel, assisted by Mr.
S. Datta. S. Datta.
S. Datta. Leonard Counsel for the petition. For the applicant. Stop. Issue notice. MS Gayan, Leonard CJC. Appears on behalf of the respondent, opposite party, is it?
Yes.
Opposite party number one.
One.
Respondent number one.
Union of India. Yes. One.
Others, you'll have to take steps.
We shall take that.
Petition, applicant to take steps for service of notice on the respondents. 2 to 7.
Yes, 2 to 7.
By registered post AD within 1 month of the date. Stop. List the matter after 4 weeks. But in the interim, comma, the office order dated 19/6/2023. Is it 19/6?
21/6/2023. We are agreed by both, my lord, 19/6 as well as 21/6.
19/6/2023. Issued by the senior manager within bracket HR. Brahmaputra Valley Fertilizers Corporation Limited. As well as the office order dated 21/6/2023. Issued by the senior manager within bracket HR. Brahmaputra Valley Fertilizer Corporation Limited shall remain suspended.
Further, your lordship protect us, not to oust us from the service. I have the specific prayer to that effect.
Will this protection not suffice?
My lord, what they may do because they're so vindictive as a lordship has seen.
It is further directed that the respondents 2 to
7
shall not oust the no, shall not shall not take any coercive step against the applicant.
Much obliged.
Thirty-two,
Made your lordship.
Lordship, I am appearing on behalf of Mr. Espora, standing counsel SSH. He needs 2 weeks time to file affidavit.
What is it?
Well,
You want?
He needs 2 weeks time to file affidavit.
your lordship has gone through it last time, my lord, that bench institution provincialization, my lord. Of course, the 2-3 times only time given. Only, my lord, since they are on limited time, my lord, that is because we have been deprived by
But
all the.
Mr. H.R.H. Chowdhury, learned senior counsel, assisted by Mr.
MH law.
MS Laskar, learned counsel for petitioner. On request made on behalf of Mr.
Espora,
S. Bora, learned standing counsel.
SSA, Sarva Sikha.
SSA. How much time?
he has received instruction, but it has come with no comments.
Oh,
so he
vacation
will
also
clear
is
it.
mentioned.
Press for 2 weeks time. Is 2 weeks time to file counter affidavit. Praise allowed. List the matter after the summer vacation.
My lord, if possible, any date back up there.
That will be difficult.
Obliged.
So you can make.
Obliged. Obliged.
33,
Yeah.
May
What
I
is
please,
this
Lord?
matter?
Yes, my lord. The matter pertains to, my lord, the use of dice code, my lord. The petitioner established the school, my lord. It is a private school, my lord. And, my lord, your lordship will find page number 47, my lord, with the permission of the respondent authorities, my lord. No objection was already granted, my lord, and accordingly, my lord, the school was established in the year 2010. And in the year 2016-17, my lord, the dias code was granted to the petitioner school, my lord.
2000?
2016-17, my lord. Your lordship will find at page number 48. my lord.
Yes.
That is the dias code, and your lordship will find the number. School, academic year 2016 and 17, and then the school code 126-18260-300-110. This is the code granted to me, my school, my lord. But in the meantime, that due to lockdown, my lord, the school was closed for some time, my lord. And when I intended to reopen the school, my lord, then I found that, my lord, the dice code granted to me was unscrupulously, my lord, used by the private respondent, my lord, hereby changing the name of the school. The name of the petitioner school is that, my lord, Ekrabari Jatiya Vidyalaya, my lord. This is the name of the petitioner school, my lord. But that name was changed to number 1 Ekrabari Jatiya Vidyalaya, and the dias code granted to the petitioner school, my lord, was used by that private respondent. So I made a representation before the authority, my lord, that was not considered, my lord. So therefore, this petitioner is before your court.
Sometime, the private respondent is also appearing. I appear for SSA, even for the petition. And let it be after vacation, in the meantime, we'll have the instruction.
You want to file your affidavit?
We'll file affidavit, or you will place instruction either way.
Okay.
Here, I'm waiting for the private respondent number 8, madam, but.
1 minute, 1 minute. Respondent 8.
8, madam, but Damsed Ali is not the owner or proprietor of Modern Silent Road Academy, madam.
That you file your affidavit
Yes,
and
ma'am.
explain.
Yes.
it. And who's respondent 9?
Respondent 9 is central government, madam.
The chief secretary.
It's in National University for Education Planning, Ministry of Human Resources.
Who's the CGC?
K Gogoi, madam, and then they call K Gogoi.
Caller. Hurt Mr.
A. Ali.
A. Ali, learned counsel for the petitioner. Stop. Mr. B. Gogoi, learned standing counsel SSA.
Yeah.
You also want to file BTC?
Yes, sir. Respondent 3, 5, and 7.
And Mr.
R.K. Musari.
R.K. Musari, learned standing counsel BTC, as well as MS A. Gayan, learned counsel for the
Respondent number 8.
jointly praised for how much time?
My lord, 4 weeks.
4 weeks time to file your respective counter affidavits. Praise the Lord. List of the police.
Obliged.
34.
May I please, your lordship? My lord, the matter is relates to disciplinary proceeding pending against the petitioner. My lord, the petitioner is a contractual employee working as a district program officer, my lord, under the SSA district mission
I
coordinator.
pray for a short time to file affidavit. It
Lord,
has been prepared and sent to the authorities, but some clarification is required, Lordship.
Lord, I do not have any objection with my respected senior friend submission, my lord. Only thing is that, my lord, I am entitled to my subsistence allowance. They are saying, my lord, that I am a contractual employee. That's why the fundamental rule is not applicable for me. But the very notification issued by the SSA Assam, my lord, they have, my lord, just a moment, just, my lord, because, my lord, I have 2 kids and family to maintain. Now, my lord, I am a penniless, my lord, no salary from last several months, my lord. My lord, may kindly peruse a notification, my lord, which says that the Assam Service Discipline and Appeal Rules at page, my lord, 46 of my petition, my lord. This is an order, my lord, issued by the Mission Director SSA that save as otherwise expressly provided in the service regulation and the financial regulation, Assam Service is hereby notified that the spirit of the rules and procedure as prescribed under the Assam Services Discipline and Appeal Rules 1964, followed by the Government of Assam for the inquiry, departmental proceeding, award of punishment, appeals, etc. shall be followed by so and so as and when any inquiry or departmental proceedings are required to be conducted in respect of the employees, contractual or otherwise, employed under the SSA Assam, my lord. My lord, this is the basis, my lord, on which, my lord, these categories of employees, my lord, are subjected to disciplinary proceeding, my lord. So if this is applied, my lord, then the other part of the, my lord, relevant rule, that is the fundamental rule, my lord, 54B, which deals with the, my lord, with my limited knowledge, my lord, subsistence allowance, that is also applicable, my lord. Here is in the instant case, my lord, what they have done, my lord, I was, my lord, arrested in connection with a criminal case by the Anti-Corruption Bureau, my lord. Some allegation was that I was charging for a bribe of rupees 10,000 from a teacher. My lord, acting on that information, I was arrested by the Anti-Corruption Bureau, my lord. Now for that arrest, my lord, till date, they have not issued any formal suspension order, not allowing to join me and work me, my lord. And on the other hand, they are also not completing the DP also, my lord. Now I am hanging, my lord. I have to survive with my family, my lord.
You have not issued any suspension order?
No, my lord.
Lordship, suspension because he was under arrest. It was deemed suspension. Lordship, everything will be clear from the affidavit, Lordship.
But what about his subsistence allowance?
Subsistence allowance, Lordship, he is not entitled because he is a contractual employee. Only the
What about
spirit.
this order 14
Yes, Lordship, I have seen it. Only the spirit with regard to the conduct of the DP, departmental proceeding. That has been followed, Lordship.
It says etc.
No, my lord. And other employees is given, my lord. I have that record also. That's
Lordship, punishment appeals review, all those things will come, Lordship.
That's why, read it properly.
Yes, Lordship, but subsistence allowance contractual employees are not entitled, Lordship. We have clarified in the affidavit that has been sent.
When are you filing your affidavit?
Lordship may take it up immediately after vacation, Lordship, on reopening, Lordship.
Then, my lord, I should be allowed to work as they have not suspended me.
Okay, let us see. Let him.
My lord, kindly, my lord, consider my condition, my lord. My whole family is.
Counsel for the petitioner. Mr. B. Chowdhury, Learned Standing
Accepted.
Counsel SSA submits that affidavit is ready for filing and press for that affidavit is being prepared and he will be filing the same within a period of 2 weeks. Accordingly, list this matter immediately after the summer vacation. We'll see.
My lord, on that day, my lord, the
That
subsistence.
day we'll consider.
Obliged. My lord, may I pray for a date, my lord? My lord, in other cases, I will not pray, my lord, but in this case, at least, my lord, a date, my lord.
26th.
My lord.
List.
Obliged.
35 and 36.
May I please, your lordship?
In item number 35, Lordship, while issuing notice on 25/5/2023, this honorable court has observed that on a returnable date, interim consideration would be made, Lordship. Lordship, what happened in this case, Lordship, the petitioner's services was utilized from 2000 as a temporary employee. He was serving as a Sokidar, Lordship. Lordship, may kindly peruse the page 37, Lordship. It was the Deputy Inspector of Schools has forwarded this letter to the Director of Elementary Education, Lordship. Page 37, Lordship. Page 38, Lordship, he was date of engagement 1/2/2000, Lordship. See Tonkeshwar Burua, date of engagement 1/2/2000, length of service 17 years, 8 months, Lordship. And he was paid only 416 rupees per month, Lordship. Only 416 rupees he was paid, Lordship, per month. And thereafter that's why, Lordship, he has approached this honorable court by filing the item number 36, Lordship. Since for paying the minimum wages, Lordship, as he was already he was serving as a 23 years, Lordship. This honorable court, Lordship, may face 44, Lordship. In that petition, Lordship, this honorable court has pleased to issue notice, Lordship. And in page 46, there is an observation, Lordship, that pendency of the petition shall not be a bar for the respondent authorities to provide the petitioner the amount entitled by him in terms of the decision in the case of State of Assam versus Upen Das and others reported in 2020 5 GLT 267. Only because of the petitioner has filed this writ petition, what happened, the respondent authorities in taking a vindicative attitude, he has released from his service by issuing the impugn order dated 18/4/2023, page 55. Page 55, without following a due process of law. During pendency of that writ petition without taking leave from this honorable court, page 55. Lordship, may I read? As per the letter received from the DE Assam Height, letter number 53/2003, Sri Tonkeshwar Burua is hereby released from all the temporary engagement at the office of the Deputy Inspector of Schools, Majuli, and this order come into force with immediate effect, Lordship. That letter is, I have annexed, Lordship, page 56. Director has issued this letter to the Deputy Inspector of Schools. May I read, Lordship? With reference to the subject matter, I would like to inform you that Tonkeshwar Burua under Majuli district has filed a case before the Honorable High Court bearing so and so to extend the benefit of fixed minimum wages remuneration of the current post of night Sokidar in the office of the Majuli till the normal superannuation age. In this regard, the parawise report as received from your end Height later reference, it is shown that petitioner was temporarily engaged on daily basis in the office of so and so from 1/2/2000 as per the order of Deputy Inspector of School Majuli dated so and so, but no formal appointment letter was issued by the competent authority. The appointing authority is Director of Elementary Education Officer. Further, there is no government provision for any such private engagement by this office. Therefore, such engagement done by the DIS Majuli is illegal and violation of provision of the government. So you are hereby asked as to how a private person was engaged in your office by violating the government notification issued from time to time. You are also directed to take immediate and severe steps to release the private person from your office by issuing a speaking order as per the government rules and procedure. So he was directed to issue a speaking order as per the government rules and procedure. But in this letter, we have categorically made statement that no focus notice was issued, Lordship. Neither the petition was heard before the passing of the speaking order because there is no.
Yes,
they have utilized his service from 2000, Lordship, by paying only 416 rupees only because he has filed this writ petition before this honorable for the minimum wages in terms of the order of the dishonorable division bench passed in the Upen Das. This impugn order was passed without following any due process law. Had there been not filed his case, his services will be utilized. Without following any due process of law. Therefore, this honorable court has. By humble prayer, Lordship, is a poor man, Lordship, only 416 rupees he was paid, Lordship, from
yes, any instructions?
Lordship, we have got instructions, Lordship, as on 9th of June 23. I have received instructions from the director, Lordship. Here, the director has said that letter has been sent to the DIS Majuli and asked to submit the parawise report. After receiving the reply, DIS Majuli, by his office letter dated 27/3/23, it is seen that it is seen that the then DIS have temporarily engaged the petitioner on daily wages, which is illegal and against government's provision. The Deputy Inspector of Schools is not the competent authority to engage any private person in office or school establishment. There is no such government provision for direct recruitment, and any recruitment is always processed as per the timelines of the advertisement and existing rules, guidelines. Further, no formal appointment was issued by the DIS Majuli ma'am. That is my instruction. I may be allowed to bring that on affidavit. ma'am.
Lordship, only my, Lordship may kindly peruse the page 28, Lordship, his appointment order, some appointment order we have annexed, Lordship, page 28, 29. It is the order passed by the Deputy Inspector of Schools, Lordship.
So according to the instruction, he is not the authority to issue the appointment order.
Exactly.
Lordship,
ma'am. Not the competent
Lordship may peruse the page 28, Lordship. Order is temporarily engaged, Lordship. This was also copied to the Director of Elementary Education, Assam. So they were aware about this, therefore, and Lordship, I have already. So Lordship, page 38, page 37, that was issued on 18/11/2017, Lordship. Regarding how many persons are engaged
Okay.
temporarily.
Heard, Mr.
K. Kolita.
K. Kalita, then the council.
Lordship, only my, Lordship may stay this.
My lord will not stay, my lord. I'll bring my
Because
my detailed affidavit.
today is for the
Mr.
in time of consideration.
Then the standing council. Elementary Education Department submits that he has received instructions and requests for some time to enable him to file counter affidavit. Praise the Lord. This the matter after 3 weeks.
Lordship may only Lordship may fix a date, Lordship.
Lordship will not give any stay, my lord, because
2000 his
I'm not
services
doing a
services
stay.
was utilized, Lordship.
See, after summer vacation, giving a date is very difficult. Dates were all. So what you can do after the summer vacation, you can make a mention and get it listed.
My lord. Deeply obliged.
37 orders.
May I be Lordship, I have only taken steps containing the new incumbents, madam, as a response number 1724, in place of the earlier incumbents. Since they are not holding those posts, madam, due to the retirement and transfer. madam. So for response 1725, I have clearly mentioned in my IA number 111150.
1 minute. Were there any notice?
Yes, Lordship, I have taken this statement. We have
Where's the office note?
office notice, Lordship, I haven't checked, madam.
Chalia, you have entered appearance.
Lordship, I am appearing for contender number 18 in this matter, Lordship.
Respond number 23 refused to accept. Respond number 22 also refused to accept.
Only Lordship, lesson number 18 file Ugalatnama, I think.
Lordship, I am appearing for 18, Lord.
18 file Ugalatnama, back it, others.
It says respondents 23 and 22. They have refused to accept. So automatically that will
Amount to accept, madam.
acceptance. But 17, 19, 20, 21 and 24. There's no ID card,
No ID card.
nothing.
That's,
So what do you want to do?
my lord, some time may be given.
Lordship, in the meantime, respondent number 18 will do the needful manner for others.
Okay, heard, Mr. Yes. Your good name, please.
Lordship.
Mr. Heard, Mr.
MU Ahmed, that's.
Amy Ahmed, learn the council for the petitioner. Mr. H. Chalia, learn the council enters appearance on behalf of respondent number 18. And prays for some time to enable.
Lordship, 4 weeks time, Lordship, because certain queries have been raised with the education
Prays for
department.
4 weeks time to enable him to receive instructions. Praise the Lord. List of the followers.
Obliged.
38.
Why is it coming for orders?
At-
Why is it coming for
Lordship,
orders?
In this case, I may be allowed to 1 week time to file an affidavit as I have already taken the dusty service on last occasion.
MS A. Badru Baral and the council for the petitioner submits that she has taken steps for service of notice on respond number 7 by dusty service and prays for a week's time to file an affidavit showing service of notice.
Must-
Praise the Lord. Please after summer vacation.
39 and 40.
And I appeal for the college, my lord, respondent 3, 4, and 5. But I need some time to file my reply. It's already ready, my lord. However, the principal is unable to visit the board right. 3, 4, and 5, my lord.
My lord,
But Mr. R.M. Dekha. Then I counsel for the petition. This is a weak petition, isn't it? Mr.
P. Bharadwaj.
Bharadwaj, then the council applying for respondents, 3, 4, and 5. Praise for
2 weeks.
2 weeks time to file a contract. Praise a lot, list the matter after 2 weeks, after the summer vacation. But why is it coming for orders?
My lord, in the second, my lord,
there is another matter, my lord, item number 39.
my lord, in item number 40, my lord, we have to yet to file the wakalat. That's why it has come up for orders.
Okay.
So we'll be doing.
41.
May I please your letter, Lordship, the matter pertains to the provincialization of service of the petitioners, my lord, as in subject teacher of English, my lord. And he was.
Why
left-
is it coming for orders? Yes, Niyuki.
My lord, here we have received the instruction. My lord, this is a matter pertains to provincialization of service. So my lord may fix it after the vacation, as the my lord, special dance is considered.
Lordship, during pendency of the petition, the petitioner filed an appeal before the under section 14, my lord. So, in the light of the appeal may be disposed of, each petition may be disposed of as the petitioner has already filed an appeal before the, on 28/10/2020, I have filed an affidavit where by filing an affidavit where appeal provision under section 14 of the Assam Provincial Education Provincial Service and Teachers Act under 2017 Act, my lord. Though the petitioner has already filed an appeal, that this matter may be disposed of to consider the petition appeal within a specified period and pass a reason order why the petitioner service has not been provincialized, as he is already recommended for the second post by the district scrutiny committee.
That we can do.
Appeal can be disposed of, my lord, within a simple.
Third MS. A. Badru Baral, let's call for the petition. Also heard Mr.
S. Nyogi.
S. Nyogi, Learned Standing Council.
Yeah, secondary education.
Secondary education correspondence, 1, 2, 3, 5, 6, 5 and 6.
5 and 6.
My lord, I will not be appearing for elementary, my lord. Elementary, my lord. A Fukan can be.
Mr. A. Fukan, then the standing counsel for the respond number 5, correct?
Yes, ma'am.
And number
Six,
4,
I will wait. Number 4, district, deputy commissioner, government, my.
Mr.
G.
J.
Begu, my lord.
J. Begu, let the government respond number 4. The petitioner school, namely Swahid Chandan Singh
High school.
High School, Nagaon district, was established in the year 1982. And thereafter, the petitioner was appointed as a lower division assistant on 12/12/1986. On a decision taken by the school management committee, the petitioner was again appointed as assistant teacher, correct?
Yes, my lord.
Assistant teacher, within bracket undergraduate. On the same date, 12/12/1986. Stop. The school of the petitioner. No, after you just say, in the meantime, petitioner acquired a BA degree in 1995 from the Guwahati University, as well as BA degree in 2002. Stop. The school of the petitioner was provincialized on 1/3/2013. However, the case of the petitioner was left out from provincialization. And the service of the response number 8 was provincialized in his place. Stop. It is the claim of the petitioner that he is senior to the respond number 8, correct?
Yes, my lord.
And the respondent number 8 does not have a BA degree. Stop. But in the meantime, the state respondents enacted the so and so Act of 2017, within brackets Act of 2017 in short. And under the said Act, process for provincialization of teaching and non-teaching staffs of various schools were taken up. Stop. The district scrutiny committee now also considered the case of the petitioner and recommended his case for the second post as assistant teacher. Stop. State level committee rejected your petition.
Yes, no. During pendency of the petition, he has filed an appeal before the state level.
No, no,
It is
District
pending
level
before the state
committee
level. committee.
recommended his name for second post. My lord.
yes, after that, state,
After that, he has filed this writ petition before this court, and pending of this writ petition, he has filed an appeal before the state level committee, which is pending, my lord, not yet decided.
no, state level committee has not considered your matter.
No decision was
Madam,
passed.
the
my lord.
writ petition has been filed. Subsequently, the appeal has been filed under
Filed,
section 14, my lord.
No, no,
before the
that's
state
fine,
level.
but then state level committee has
That is
not,
pending, my lord, not
That
yet
is
decided.
pending.
not considered the matter.
No,
My
not
lord, it's pending.
pending, my lord.
Oh,
Not
after the district scrutiny committee recommended your matter,
Yes,
whether the state level committee has considered your matter or not, or was it rejected by the state level committee?
the district level scrutiny committee after recommended my name before the director of secondary education, and director of secondary education did not provincialize my service under 2017 Act, my lord.
I have no idea that whether the district level scrutiny committee has placed the matter before the state level committee.
Stop. As the case of the petitioner is yet to be placed before the state level scrutiny committee. Petitioner approached this petition, approached this court by way of the present petition. Stop. During pendency of this petition, petitioner also filed an appeal under section 14 of the Act of 2017.
On 10/10/2022.
10/10/20.
10/10/2022 before the state.
10/10/2022. Before the state levels.
Scrutiny
But when the state level scrutiny committee has not considered your matter, how can you go before that? How can you go? It says you can approach the state level scrutiny committee
Yes,
against any recommendation of the district scrutiny committee.
yes, my lord.
District scrutiny committee recommended your case.
Yes, my lord.
Why should you appeal?
District scrutiny committee recommended my name as a for second post, my lord.
Huh.
And that the district committee has placed the matter before the director of secondary education to provincialize my case under 2017 Act.
So director is
Yeah,
the state level scrutiny
yes,
committee.
Yes, the director did not consider my case and published a list under on 21 where
So
my
it
name.
was rejected.
Yes, my lord. Rejected, but not mine, but they were not provincialized my service. Why they are not provincialized?
Then you'll
my-
have to appeal before the state
State
government,
level-
state government.
State level scrutiny committee under section 14, my lord.
Hukan. District scrutiny committee recommended the petitioners.
Yes, my lord.
It was placed before the director. Obviously, director is the chairman of the state level scrutiny. committee. Scrutiny did not consider the matter, issued a notification provincializing the services of other
The other,
teachers,
other teachers.
teachers, but rejecting the, did not consider the case of the petitioner. So obviously, if it is a grievance against the decision of the state level scrutiny committee. So it has to go before the government. So you've filed your appeal before the wrong forum.
No, no, my lord. I have filed an, I have, my name was recommended by the district scrutiny committee. Thereafter, the petitioner is waiting for that his service may be provincialized. But the director of education, while publish a list of candidates for provincialization in similarly situated persons, again, I am left out under 2017 Act, my lord. Yes, as I am agreed that my service was not provincialized under 2017 Act, though my name was recommended by the district scrutiny committee. Then I'm being aggrieved of the action of the director. I prefer this petition before this court. And after during pendency of the court, I preferred an appeal before the state level scrutiny committee.
That's
That
right,
is
that's-
also pending.
That is what I'm saying.
That is all pending.
You are aggrieved by the action of the director.
Director, my lord.
Who's the director?
Director is the,
Chairman of the state level
Yes.
selection committee.
no, secretary is the said, no?
No, no.
Director.
So you'll have to file an
But
appeal
director
before the
till-
secretary of school education.
But the director till date, no decision has,
Obviously, he won't take a decision. How can you sit over his own judgment?
Chairman of my lord, district scrutiny committee is deputy commissioner and my lord, state level committee director.
right,
That's what. So state level committee did not consider your matter. Director did not consider your matter. That is the state level committee.
but why they did not pass any region order. Some region order may be passed, why my name was not considered for provincialization. That may be done,
That's why
that is why.
you have appealed before the wrong forum.
I placed an appeal before the section under section 14 before the director, my lord.
Read section 14. Before you read section 14, read section
13.6.
13.10.
10.
10. Happy. There shall be one state level scrutiny committee at state level for verification of recommendation received from the district scrutiny committee with the following member, namely Director of the concerned Department of Education, that is Chairman, Joint Director, Deputy Director of the concerned Director,
Okay.
Member Secretary.
So who's director?
Yes, my lord.
Director did not consider your matter
On to the 2021,
and provincialize the case of the other day.
other one,
Correct.
yes,
So obviously you agree by the decision of the director.
yes, my,
So who's the director? He's the chairman of the state level scrutiny
yes, my,
committee.
yes.
Then you file an appeal before the state level scrutiny committee. How can that be? You'll have to appeal before the state government. After that, you read section 14.
State level scrutiny committee shall be the appellate authority against any recommendation of the district scrutiny committee. And the state government in the concerned administrative shall be the appellate authority against any recommendation of the state level scrutiny committee. Yes, ma'am.
Isn't that?
Yeah.
What did I say now? I forgot.
Any recommendation of state level.
It's a doing pendency of lead petition. I said that. As the case of the petitioner was not considered by the state level scrutiny committee after being recommended by the district scrutiny committee, this court is of the considered opinion that the petitioner has met the appeal under section 14 of the Act of 2017 before the wrong court. Inasmuch as the said appeal should have been filed before the state government against the decision of the state level scrutiny committee. Stop. Accordingly, this petition is disposed of. Directing the petitioner to file a fresh appeal under section 14 of the Act of 2017 before the Secretary, School Education Department.
Yes, madam.
School Education Department. Within a period of,
1 month.
you will file your appeal within 1 month. You can't do it early.
Yes, open within 2 weeks. I
Within
have
a period
to
of 2 weeks.
inform the petitioner, my lord.
After the Secretary States, the School Education Department on receipt of the appeal shall dispose of the same. After giving a personal hearing to the petitioner as well as the respondent number. Is it 8 or 7 and 8 or 8 only?
It was the headmaster. It was the private respondent and 7 was the headmistress.
So your grievances against respondent number 8 is
8, my lord. 2 was junior
as
to
well
me
as
and
the respond number, as well as the respond number 8. And after. Dispose of the same by speaking order. And in accordance with law. Within a period of 1 month
yes, ma'am.
from the date of receipt of the appeal. The conditions in the.
Always.
42.
Matter is to
Yeah, please,
contempt
Lordship,
petition, Lordship.
This is a case for medical reimbursement, my lords. I have informed the petitioner, my lords. The respondent, Lordship, contempt number 1 has made a request, my lord, that if the petitioner accompanied by the advocate also, can visit the Ka Bhavan once, my lords, all the grievances that they have, that can be addressed, my lords. In that case, my lords, I seek 4 weeks time. In the meantime, my lords, I will give them the officer in charge who is handling the matter, my lords. They will coordinate with the petitioners, my lords, because in the court, my lordship, 4 weeks time will, lordship, the order.
My query, Lordship, the petitioner should get this medical reimbursement.
Lordship, that
If they wants the petitioner to appear, he will appear, Lordship.
If Chalia is giving you an opening.
Yes, I will.
You take
yes.
advantage of that.
Yes, yes.
Lordship,
Definitely,
Mr. After 4 weeks, my lords, in between.
On request, heard Mr.
S.N. Krishna Traya.
Is Krishna Trayal, then it comes to. On request made by Chalia, then it council applying for respond number.
1 and 3, lordship.
1 and 3, list the matter after 4 weeks.
That observation may be made, Lordship.
Lordship, I'll give him that lordship may monitor the matter after 4 weeks, my lord.
Obliged, Lordship.
43 and 44.
May it please, Your Lordship. But this is a review preferred by the state, my lord, against the order dated 19/11/2019, whereby my lord, direction was issued to correct the date of birth of the petitioner, my lord. 46, page 46, my lord.
Why is it coming for order?
It's a review.
But otherwise, they have also filed their
Review.
affidavit also, my lord.
It can be disposed of today also, Lordship, because it's pending for a long period of time. Because the document was there, and based on that document, the direction was given.
What is the order?
Or order page 47, my lord. Paragraph 3, my lord,
1 minute.
page 47.
Wow.
The grievance of the petitioner is that the date of birth of the petitioner has been wrongly entered in the service book as 31/7/1958. It is the case of the petitioner that if the said wrong entry of the date of birth in the service book remains, the petitioner would have retired from service on 30/7/2018. However, the petitioner submitted an application in the year 2015 for correcting the date of birth based on the admit card of the HSLC examination, in which the date of birth of the petitioner was correctly shown as 1/12/1967. The said application of the petitioner was duly considered by the Director of Elementary Education, and the Director, having been satisfied with such a plea of the petitioner, wrote to the Commissioner and Secretary to the Government of Assam Education Elementary Department on 30/7/2015, seeking advice as regards the correction of the date of birth of the petitioner. My lord, next. Paragraph 4, my lord, as the said retirement based on the wrong date of birth of the petitioner was nearing, the petitioner again moved the Director of Elementary Education, who in turn again requested the Commissioner and Secretary of the Government of Assam by letter dated 15/2018 for necessary instruction in the matter. In response to the said communication from the Director of Elementary Education, the Undersecretary to the Government of Assam Elementary Education Department wrote to the Director stating that the matter for correction of date of birth of the petitioner has been examined by the department and accordingly directed to necessary steps for correction of the date of birth of the petitioner as per certificate forwarded by the Secretary, Board of Secondary Education Assam, with intimation to the department white letter dated 10/5/2018. So my lord, may skip paragraph 5, 6, 7, my lord, 5 and 6, my lord. Then accordingly, the petition is allowed, setting aside the impugned order dated 15/5/2018, and the authorities are directed to do the needful in terms of the direction issued by the state government in letter dated 10/5/2018, issued by the Undersecretary to the Government of Assam Elementary Education Department. This court has also noted that this court had stayed the aforesaid impugned order when the matter was taken up on 31/7/2018. So direction was issued to correct the
What is
date of
this
birth.
order dated 15/5/2000.
Exactly, my lord. It is Annexure A, my lord. Page 14.
Which?
Page 14, my lord.
1/4.
1/4. In inviting a reference to the letter and subject cited above, I am directed to state that the matter for correction of date of birth in respect of Sri Arun Chandra Soikia has been examined in this department. Now you are requested to kindly correct the date of birth of the incumbent as per certificate forwarded by the Secretary, Board of Secondary Education, with intimation to this department. So on the basis of this letter, my lord, direction was issued to correct the date of birth, and accordingly, that petition was disposed of, my lord. My lord, now kindly turn to page 15, my lord.
No, impugned order 15/5/2018.
Yes, my lord. On the basis of this letter, my lord, the impugned order was passed.
Where's the order? Impugned order.
Impugned order, my lord, page 47. This is the impugned judgment, my lord.
No. In the judgment, para 7,
Whereas
page 48.
15/5, my lord.
Yes.
Yes, 15/5, my lord. Page 36. By this impugned order, he was allowed to go on retirement, my lord. Considering his date of birth as 58, my lord. My lord, kindly now turn to page 15, my lord.
Page.
It's letter dated 10th July 2019. Office order. The government instruction issued from Elementary Education Department, white letter number so and so, dated 10/5/2018, in respect of the matter for correction of date of birth of Sri Arun Chandra Soikia, Senior Assistant, Office of the Deputy Inspector of School, Soraido, is hereby cancelled. So this letter, on the basis of which direction was issued to correct the date of birth, my lord, that was cancelled, my lord, by this order, my lord.
Was this placed before the writ court?
No, my lord.
Why?
Because, my lord, before we are filing any affidavit in that matter, my lord, that matter was disposed of on the basis of this letter, my lord. That is the reason, my lord, we could not produce this order. This order and subsequent communication. Communication at page 16 also. It was informed to the director, my lord. Page 15 and 16. 15 is the office order and 16 is the communication of the said office order, my lord. But we could not produce before the writ court, my lord. That is why that the impugned order was passed, directing to correct the date of birth on the basis of an order which has already been cancelled. And if we consider his date of birth as, my lord, 67, then, my lord, his entry to the service in the year at the age of 9, my lord. That cannot be, my lord. A public servant cannot be appointed at the age of 9, my lord.
When did he enter service?
As per, my lord, our record, my lord, 31/7/1958, page 38, the service book.
Page 30.
Page 38. This is the service book, my lord.
He entered service on?
31/7/1958.
No, that is his date of birth.
Yes, my lord. His date of birth, my lord. His entry to the service, my lord, on 15/11/1976. That is page 39.
He's claiming his date of birth as?
His 1/12/1967, my lord. If you consider it 1/12/1968, then his entry to the service is at the age of 9. So this is the two grounds for seeking review, my lord. One, my lord, the office order was cancelled on the basis of which direction was issued to correct the date of birth to the director, my lord. That was cancelled and that cannot be brought to the.
What is your explanation to that you could not produce? How do you explain?
Well, kindly see the grounds, my lord, at page 7. Page 7, my lord. Ordered, since no affidavit in opposition was filed in the opposite writ proceeding, therefore the stand of the department could not be placed before the the Honorable Court against the relief sought for by the writ petitioner opposite party. The basic grievance of the writ petitioner opposite party in the state proceeding is that his date of birth was wrongly recorded in the service book as 31/7/1958 instead of 1/12/1967. The writ petitioner opposite party requested the department to correct his date of birth on the basis of his HSLC admit card, and the government right letter dated 10/5/2018 directed the director to correct the date of birth of the writ petitioner. However, the instruction to correct the date of birth of the writ petitioner opposite party contained in the letter dated 10/5/2018 was subsequently withdrawn by the office order dated 10/7/2019. Unfortunately, such subsequent withdrawn of government instruction could not be brought to the notice of this honorable court, and this honorable court, on the basis of the letter dated 10/5/2018, allowed the writ petition number so and so by directing the department to do the needful in terms of the direction issued by the state government in the letter dated so and so. So, madam, since we have not filed any affidavit in opposition, and that instruction was also not with us, my lord, that is why we could not bring it to notice of this honorable court, my lord.
What is your second ground?
Second ground, my lord, regarding my lord, 9 years, my lord.
That
If-
you could have taken in the, when the proceeding was taken up. Isn't it?
Because, my lord, during-
That ground you could have taken when the proceeding was taken up.
that was, my lord, and in fact, while that writ petition was disposed of, my lord, there was no instruction from the department, my lord, while it was taken up, my lord.
In
And my
any
lord,
case, all the documents were there.
maybe, my lord, that
with
time, my
regard
lord,
to his age.
that-
When he joined service, all
yes, my
these
lord,
things were
the
there.
council who was argued during that time, maybe it was skipped, my lord. But in any case, my lord, a person cannot enter into a government service at the age of 9, my lord.
Yes.
So we have filed our objection. In the objection, we have taken a specific plea that there is in the review application, they have not raised any legal ground with regard to this error apparent on the face of the record. Because this
Error apparent on the face of record is the two documents.
yes,
Which they could not place, and therefore this
Exactly.
court had to, had passed a wrong order.
wrong order. But the thing is that lordship, this particular document was not produced before the honorable court. It was not placed at the relevant point of time. So the question of not taking into account that particular document does not error. So that was never been placed. Now they are placing it in the review application, but that was not placed before the honorable court. The
That
place-
is why what they are saying, that they had not received appropriate instructions and these documents were not in their hands. Therefore, they could not place it. Had they been properly instructed, they would
No,
have
the,
placed the
if
same.
your lordship
before
kindly
the
see
court.
the order which has been put to challenge before the honorable court for review. In that particular order also, there is a reflection. The repeated, the time was given to the government to submit their affidavit in opposition. That was not filed before the court. So there is no apparent error apparent on the face of the record. So in that view of the matter, how this review application is maintainable, they can prefer an appeal on the ground of that subsequently this particular order has been set aside. And that particular order which has set aside the previous order for correction of the date of birth in the service book, that was also done without issuing any notice to the petitioner. Because when my application was pending before the concerned authority, I should have been served a notice with regard to the this particular order which has been cancelled. I was not served any notice for, because the metric certificate, all these documents are there. It was not put under challenge. So these documents are sufficient enough to establish my actual date of birth.
What do you say about you entering service at the age of 9 years?
So that aspect of the matter, lordship, on the last occasion also, even in the objection, I made a mention, because that particular period from 9 to 18 years should not be taken into account for my pensionary benefit. I'm not saying because it is an irregular appointment during that was prevalent in 50s, 60s and 70s. These things were prevalent because I was appointed as a personal assistant, personal boy of the deputy inspector school. So that was done. But saying that this at the time of my considering my pensionary benefits, this particular period should not be taken into account from 9 to 18 years. And there is no denial to the fact that I was not discharging my service. I was discharging my service, and accordingly, subsequently, it was regularized. What has happened that my entry point is at the age of 9 years. I can understand that this is before 18 is not possible. It's an irregular appointment. So this irregular appointment can be corrected by way of not considering this particular period, 9 to 18 years. And I have specifically made a mention in my objection also. Because the SEBA certificate and all these documents are there, which goes to show my actual date of birth. And accordingly, that was rightly corrected by the authority
during the relevant period of time. So giving a direction that it should not be considered that particular period. For considering my suspensionary benefits. There is a judgment of this honorable court also. They rely on that judgment. In that particular judgment also, Lordship, there's a direction given that that particular period should not be taken into account. I can give this judgment also. Judgment of
That's a different issue. I'm only on these two documents. 10 July 2019,
18.
18, 19,
19, my lord.
and 10 May 2018.
No, that was this particular order, the previous order issued by the elementary education, the director of elementary education, that was set aside by the subsequent order on 15th of February 2018. But the previous order, if your lordship kindly see, my learned friend has referred to the first order. That particular order, lordship, your lordship kindly see, the verification was there. It is seen that the date of birth recorded in the service book as on 31/7/2015 respect to Arun Soikia. The incumbent concerned has submitted a photocopy admit card of HSC examination showing a date of birth as such and such and requested to consider. The government is therefore requested to advise regarding the correction of the date of birth. So since all the documents are there, substantiating my actual date of birth, so accordingly that order was passed. And my learned friend is relying on the document by which that was set aside, and there is no reason for not considering that particular thing. Ground of joining the 9 years is an irregular appointment. But my actual date of birth, there is no denial to my actual date of birth, and there is no challenge to my actual date of birth. So whereas the certificate of Sheva is
See, the issue is this, you're going to retire when? 2018.
18.
You made your application?
No, that was in the year 2015. That 3 years period is there. Before 3 years, I made an application 2015.
What 3 years? Is it 3 years or 5 years?
3 years now. Prior to 3 years, 2018 and 2015, I made an application for that.
Where is that provision?
Yes, the application in the impugn order, lordship, the reflection is there, Lord. So lordship, kindly see page number 47. The petitioner submitted an application in the year 2015 for correction of date of birth. Page number 47. Page number 47, lordship, the second paragraph. The grievance of the petitioner is that the date of birth of the petitioner has been wrongly entered in the service book as 31/7/1958. This is the case of the petitioner that if the said wrong entry in the date of birth in the service book remains, the petitioner would have retired from service on 30/7/2018. However, the petitioner submitted an application in the year 2015 for correction of date of birth based on the admit card, in which the date of birth of the petitioner was correctly shown to be 1/12/1967. Was duly considered. That was duly considered lawful during the relevant period of time. By the Director of Elementary Education, the director, having been satisfied with such a plea of the petitioner, wrote to the Commissioner Secretary to the Government of Assam Department on Authority seeking advice as regards the correction of date of birth of the petitioner.
Okay. Any other?
And page number 35, lordship, annexure C. The Under Secretary Government of Assam accordingly give a direction to the Director of Elementary Education for correcting the date of birth.
inviting a reference to the letter and subject side above, page number 35 of in Exhibit C.
This we've already considered, that is there in, that is also in annexure A,
Hmm.
page 14, it's the same one,
Yes, my lord.
it's the same one.
Hmm.
Issue is this, Chowdhury. The court, while disposing of the matter, was not apprised about the cancellation of the earlier notification, earlier intimation. Therefore, this court passed the order. So it was an error apparent on the face of the courts. So in that view of the matter, I think we'll have to review the order and dismiss your writ petition.
Now, Lordship, here in this case, this aspect of the matter with regard to the
What
correction
you
of date
want,
of
you want to have the order recalled and have a hearing of the,
exactly, I think it will be better. Lord. Because then I will put a challenge to this particular order which has been delayed in my learned friend, because that was not put to challenge in the previous PPT. Because this particular order has been passed without any notice to the petitioner, because the specific communication was from the Under Secretary Government of Assam to the Director for Correction of Data.
Heard NG Katanian and the counsel for the petitioner, for the review petitioner. Heard NG Katanian and the standing counsel,
Education Elementary Department.
elementary, education elementary department for the review petitioner. Also heard Mr. S P Chowdhury. Then the counsel appearing on behalf of the opposite party number,
Opposite party. Lord.
the sole opposite
Sole
party, oblique writ petitioner. Stop. By this review petition, the petitioner is praying for review of the order dated 19/11/2019, passed by this court in WBC 5042 of 2018, whereby the state writ petition was allowed and direction was issued to do the needful in terms of the direction issued by the state government in the letter dated 10/5/2018, issued by the Undersecretary to the Government of Assam Elementary Education Department. Stop. Consequently, the impugned order by which the petitioner was made to retire
Yes.
with effect from
With effect from my lord.
Retire from service on 37/2018.
on 37/2018 was set aside and by which the opposite party, the petitioner, was set aside and the opposite party was allowed to continue in service until appropriate order is issued by correcting the date of birth as directed by the state government. Stop. Para. Then the standing council, elementary education, appearing for the review petitioner, submits that after the order, after the communication to the 10th May 2018, issued by the Undersecretary to the Government of Assam, an address to the Director of Elementary Education Assam to correct the date of birth of the opposite party of liquid petitioner as per certificate forwarded by the Secretary Board of Secondary Education. The government, the Commissioner and Secretary to the Government of Assam, by another office order dated 10th July 2019, cancelled the letter dated 10/5/2018. Stop. Subsequent thereto, the Joint Secretary to the Government of Assam, by another communication dated 10 July 2019, addressed to the Director Elementary Education. Requested to cancel requested to treat the date of birth of the petitioner of the opposite party of liquid petitioner in the office of Deputy Inspector of Schools, Jaradio, as the original date of birth submitted at the time of joining, and his date of retirement of superannuation may accordingly be treated as per original reports. Mr. N.G. Katania, counsel for the review petitioner submits that the said two documents, namely office order dated 10 July 2019 and the communication dated 10 July 2019, 10th July 2019 and the communication dated 10 July 2019. Put that 2019 only?
Both are 2019, madam.
2019 could not be placed before this court when the order dated 19/11/2019 was passed in the WBC 5042 of 2018. As the council was appealing for the review petitioner was not properly instructed, no counter affidavit was filed in the petition. He therefore submits that if the said two documents were produced, this court would not have passed the order directing the respondents, directing the review petitioners to correct the date of birth of the opposite party of liquid petition. Stop. Mr. S.P. Chowdhury and the counsel for the opposite party on the other hand submits that there is no error apparent on the face of the court, and therefore this review petition should be dismissed. Stop. But after hearing the learned counsel for the parties, no, I've heard the learned counsel for the respective parties. Stop. This court has considered the office order dated 10 July 2019, as well as the communication dated 10 July 2019. Stop. A perusal of the same would indicate that the earlier permission granted by the government for change of birth of the date, for change of the date of birth of the opposite party of liquid petitioner issued by the communication dated 10th May 2018 was revoked. Stop. The submission made by the standing council for the review petitioner that these two documents could not be produced before this court due to no proper instructions is also taken into account, comma. This court on consideration of the same is also of the considered opinion that if these two documents were placed before this court, if the office order dated 10 July 2019 and the communication dated 10 July 2019 were placed before this court would not have passed the order dated 19/11/2019 in the said petition. Stop. Accordingly, I am convinced that there has been error apparent on the face of records. Accordingly, the order dated 19/11/2019 passed in WBC 5042 of 2015 is recalled. Stop. Let WBC. At what stage was it disposed of?
Admission stage.
Let
Five-
WBC
5042,
number 5042 of 2018 be listed in the for admission after the summer vacation. Review petition is accordingly allowed.
Obliged, Lord.
So
45.
What is this IA?
In the writ petition, there was an IA, my lord. No, couple more, Lord, I think.
Certain amount was supposed to be released and that was not released and that's why the IO was banned. So we'll place it at the time of this pressing the writ petition. Is that it? Okay.
45.
45, my lord, I have received. Come in.
My lord, as per the last order, my lord, we are supposed to take instruction, my lord, as per the status of the compliance. My lord. It was an appointment, and I had the order to begin.
What government letters?
We have thought for some more clarification from the mission director, SSA.
My
and
lord,
the-
my friend was kind enough, my lord, to give me the letters, my lord. By way of the one letter, my lord, on 14/6/2023, the government requested the mission director SSA to intimate the government about the UDIS, my lord. This is, my lord, in my humble submission, my lord, is, my lord, in violation of the act as well as the order passed by this honorable court, my lord. This is a higher secondary school and there is no requirement of DIAS code, my lord. And by the second letter, they again sought for some clarification from the Assam Higher Secondary Education Council, which they already received from that authority.
Who is this joint committee?
Joint committee, my lord, the committee constituted pursuant to the provincialization process, my lord, to verify that.
Is it provided under the act?
No, my
No, my lord, otherwise it is not provided under the act, my lord.
Is it a?
But that committee is verifying the particulars of the school, my lord.
Someday somebody is going to come challenging this joint committee.
Otherwise, it is not provided in the act, my lord.
And my lord, the joint committee has already verified our claim, my lord.
And you guys, good. Isn't it? That's good.
Yes, my lord.
It is not required, my lord.
Is it required under this?
For secondary education, it is not required.
Not
Then-
required, my lord.
What are you doing?
Maybe, my lord, there, whether this person are working or not, that can be verified from the UDIS. Probably for that reason, my lord, the UDIS data was sought for, my lord.
School has been provisionalized, isn't it?
No, my lord.
School has also not. been
Not provincialized.
And for the entire school, my lord. So, my lord, because of the reason that whether this person are continuously working or not, or to verify that fact, my lord, UDIS data of UDIS was sought for. I will fix it after,
My lord,
after vacation, my lord. I will-
without any authority, my lord. Without any authority.
Yes.
So, my lord, my lord, I'd like to submit, my lord, after perusing the copies of the order, my lord, government letter. My lord will be pleased to direct the person concerned to appear personally before lordships to intimate lordships why he is so reluctant to comply with the order passed by this honorable court, my lord. It has attained finality, my lord. They have not preferred any appeal, any review.
What
petition.
order was passed?
My lord will find the order at page 15 is the effective portion, my lord. Page 15, my lord will come to page 14, my lord, last line. Page 14, last line. In this sentence, in this petition. May I read? In this petition, the records reveal that the district scrutiny committee as well as the state level committee had recommended the present petitioners for provincialization after having accepted the service credentials to be genuine. If it is so, we do not find any reason as to why the education department shall not bring the process of provincialization of petitioners, which logical and by passing appropriate reason order. In doing so, if the authorities are of the view that the credential of Srimati Saleha Begum, this is not a petitioner in this case also, my lord, would be unacceptable, the claim of the state person may be made subject to outcome of writ petition she had instituted, separate writ petition. But at the same time, the process of for provincialization of the present petitioners be brought to its logical and
by passing a reason order. The requirement be done by the respondent number one, Commissioner Secretary in the Education Department. The Commissioner Secretary, Government of Assam, Second Education Department shall pass a reason order upon verification of the record, and same be done within a period of 2 months from the date of receipt of a certified copy of this order. They have already verified, my lord. The state level committee, joint committee approved our case for provincialization, but there is no reason why.
Direction is
still
crystal
it
clear.
has-
Otherwise, direction is clear, madam, but the
What more do you?
only reason, madam, I can comprehend from this.
I'll call for personal appearance.
My lord.
Only one difficulty from my part, madam. Here, madam, I'm not filed my wakalat now, but I'm appearing just as a standing counsel.
But the person concerned is aware of the order, my lord. He has written all this.
Otherwise, he is aware, madam.
He is aware, my lord.
So, my lord, give me time till the reopening, my lord, so that I can convey this, my lord. And on,
Otherwise, I'm calling for
My lord,
personal.
it
yes,
has
on
already
next
been
day, my lord,
conveyed,
if
my lord.
no, if next day, no concrete instruction forthcoming, my lord, then my lord may.
Well, until and unless he personally present before Lord says, my lord, I think no
Let's
complaints
see-
order will
let
be
us
passed.
see What Khataniya can do for you.
Yes, my lord. On
Next
reopening,
date, I'm going to pass the order now.
yes, my lord. Next date, my lord.
Kindly
No,
But
this may be
I am
recorded.
Dekal and counsel for the petitioner. Stop. Mr. N.J. Khataniya, legal counsel, appearing for the respond number 3.
yes, my lord. I have.
Please go ahead, Prabhu. Totally.
Respond number 3.
Yes, madam.
On instructions. Submits that the joint committee examine the case of the petitioner, correct?
Yes.
That the joint committee examine the case for provincialization of the services of the teaching and non-teaching staffs of HAM Girls Senior Secondary School, Morigaon. Was held on 13/6/2023. And this minutes of the said committee has been sent for approval. Stop. Pursuant to the decision taken, the government by letter dated 14/6/2023 wrote to the mission director SSA, the secretary to the government of Assam, Department of School Education wrote to the mission director SSA to submit the detailed UDICE report for the year 2014-2017 in respect of HAM Girls Senior Secondary School, Morigaon at the earliest. Stop. He therefore prays for some more time to enable him to receive appropriate instructions. The prayer is allowed as, the prayer is allowed. List the matter immediately after the reopening of, the summer vacation. Stop. If no, you file compliance report, isn't it? You are filing compliance report.
Compliance, my lord, if no concrete instruction, my lord. Maybe compliance may not be
If
possible.
no appropriate instructions are received by the learned counsel for the respondent number 3 on the next returnable date, the personal appearance of the concerned respondents shall be considered.
Right. And deeply obliged.
Obliged, Lordship.
46.
In item 46, my lord, I am praying for some time, my lord, on behalf of Mr. R. Motundar, my lord.
Next week. Lordship, here, what has happened is the order dated 11/5/2022 is yet to be complied with. Though they say that they passed the speaking order, but that the speaking, from what I understand of the speaking order, it does not
It is not in compliance with the honorable court's
Okay,
order.
heard MSD Burgoyne and the counsel for the petitioner. On request made on behalf of Mr. R. Majumdar, learned counsel appearing for the respondents.
Next week,
List the matter after.
After.
next week. Na? Any.
After reopening, my lord.
Up to the summer.
Lordship, a date may kindly.
Fixing a
Oh,
date after
Lordship,
summer.
immediately.
Obliged, Lord.
47.
Even also we need some recommendation, Lordship. The matter is under, it is before the DPC, Lordship. It's for the Departmental Promotion Committee, Lordship. Lordship may pick it after vacation.
Heard,
Lordship, we'll
Mr.
check.
My lord, in this case, my lord, the petitioner has passed away, my lord. My lord, I may be allowed to substitute the petitioner with next of his legal heirs, my lord. Till the compliance with the order, my lord.
Mr.
PH Core, my lord.
PH called on the counsel for the petitioner submits that the petitioner passed away on. Died on.
My lord, on 14th of November 2022.
14th of November 2022. Stop. He therefore plays for some time to enable him to file a substitution petition. Stop. Praise allowed. List the matter after the summer vacation.
Obliged, my lord.
Obliged, Lord.
48 and 49.
May I please your lordship, item 48 is a contempt petition for a violation of the order passed by this honorable court, lordship. The order starts at page 19 and the operative part is at page 49, lordship, the direction part.
My lord, before my learned friend start, lordship, the order against which this contempt petition has been filed, lordship. Against this order, a review petition filed by the respondent number 5 of that writ petition, lordship, and the review petition number 125/22 that is pending. So she has also lordship appeared in that, the petition also appeared in that contempt review petition, lordship.
I have not appeared in the,
I think notice has been issued. I think she has also received notice, I think, by this time.
lordship, we have not received any notice in the review. I'm not aware.
The
of
order
the
that
review.
has been challenged in this lawsuit contempt file, that has been under challenge in the review petition, lordship. And that is pending.
Order 21/7/2022.
21/7/22, yes.
22.
In past in WPC number 6721 of 2018.
Hmm.
And review petition number is 125 already 2022. And the petitioner is the party in that review petition.
Okay, heard MS.
A Talukdar, lordship.
A Talukdar and counsel for the petitioner. Stop. Mr. SMT Chisti and counsel for the petitioner, for the respondent number.
I have been asked by the honorable court to appear as a
Lordship, no
department.
notice has been issued till now in the contempt, lordship.
And because of that, no notice has not been issued. I was directed by the honorable court to take the that particular
Standing
instruction.
Council Department of School Education submits that a review petition has been filed against the order dated 21/7/2022 passed in WBC number 6721 of 2018.
80.
Stop. Considering that the review is pending pending for disposal. List this matter again after.
Lordship, can the
Forwards.
matter come along with the review, lordship?
No.
No, it is separate. Everything is separate. If the review lawsuit allowed lawsuit, that this order will
After
go.
4 weeks.
4. Yes.
Applied,
49, I was appearing for respondent number 49.
Okay.
There are the
Uh,
multiple
Miss-
cases
Miss-
lawsuit.
Mr. So-and-so, learned counsel appears for respondent.
4 in 49.
4 in WBC 6262 of 2022.
50.
My lord, this is a contempt case, my lord. For willful disobedience of the order dated 19/7/2019.
What is this IA?
But IA is for impleadment of respondent number 3 and 4, my lord. We have impleaded and we have also filed an affidavit intimating service of notice. My lord. But may I take you through this order 23 to
No, they have to
2020?
appear first, lordship. The service, whether it's complete or not, they have to appear, lordship. Only then
for my post because earlier respondents, they were already retired.
Were they implemented in the contempt?
My lord, because the earlier contemner was transferred from the post.
1 minute. There's no implement.
My lord, we have, this is,
IA 3092 is for what?
is for impleading respondent number 3 and 4, my lord.
Oh, I see. They have not been implemented yet.
My lord, we have,
You are to intimate them about the judgment.
my lord, we have also, we have filed an additional affidavit showing service of notice on them, my lord, after impleading, my lord. Implement was allowed or not?
Implement has not been
Not yet
allowed,
allowed.
council.
How can you file it? My lord, it may be allowed now.
How? There's a direction here
My lord,
that whether you have intimated the present incumbents whom you are
My lord.
seeking for implement
we have filed
with
an,
regard to the judgment.
my lord,
Ask by this court.
yes, your lord.
Have you produced copies of the judgment? Have you?
Yes,
met
we
with
have
the
filed an
president?
additional affidavit, my lord.
Where's your additional affidavit?
Filed on 2/5/2023, my lord.
This is showing service of notice.
My lord,
For what? Why should you go and serve notice when you have not, when they have not been implemented?
Lord, we have,
Now you're committing contempt now.
I think he is not understanding the procedure laws. That is the difficulty, lord. My lord, last time we were told that we will have to
Read
serve.
this order. Read this order. Have you read this order?
He should have consulted with some senior law.
Have you read this order or not?
My lord,
Have you taken the steps directed by this court?
my lord,
What steps have you taken?
my lord, we have filed this additional affidavit.
Have you read para 3 of the order 21/2023?
Order dated, my lord.
21/2023. You don't have the order. Give him this. He's wasting my time.
Lord, may adjourn for the day. I will. Yes, Lord, may adjourn. I will.
On request made by Mr.
A.W. Aman.
A.W. Aman, release the matter after the summer vacation.
My lord.
Legal counsel for the applicant.
51, 52, and 53.
My lord, in these three matters, this is pertaining to my lord suspension, then my lord the disciplinary proceeding, then my lord not giving us furnishing the documents. Now in two repetitions, they have not filed my lord affidavit in opposition. But then my lord, my learned friend has agreed that if it is fixed for hearing, my lord, sometime in July last part, my lord. Then in the meantime, if they file it, file, or otherwise, my lord, your worship may fix it for hearing, my lord.
We have already filed one affidavit, probably this will cover all the matter. And other records is with me. We can rely on that.
So our joint prayer will be, my lord, let it come on 20th of July, subject to your lordship convenience.
Heard Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Mr.
M. Datta.
M. Datta, Learned Counsel for the petition. Stop.
Let it come
Also
for
have
admission.
Mr.
on-
Ezekiel, Leonard, Standing
As-
Council,
Assam
Assam University. Stop.
Let it come on 20th for admission method and endeavor will be made to
That's
dispose of.
made by the- Notices are complete.
Yes, sir.
Yes, ma'am.
I don't know why it's coming up for orders.
It has to come for admission, ma'am.
This the metro 20 will be some difficulty. 27.
Fine.
Not admission column.
For admission, your lordship will kindly observe matter that the endeavor
The
will be made.
admission column.
Always.
Much okay.
54. Well, that line may kindly be added, matter. The endeavor will be made to dispose
An
of.
individual will make a dispose of this.
Highly
requisition.
obliged.
Yes. It is a complaint case, my lord. Your lordship's order is starts at page 9. And your lordship's direction is at page 15.
Before my learned friend start lordship, here I want to clarify lordship. This is a new contempt, 2020, first time it has come, but he has made Vijay Chaudhary as a respondent. He is no longer holding the post lordship. He is suffering from a serious illness and for last couple of months he is on leave and don't know when he is going to. Now Narayan Kaur is a
My
secretary.
lord, my humble submission, let me submit my case for issuance of this
No,
notice.
before
He's
for
not
department,
getting
I have
his
to-
salary, lordship direction is very much clear. Let notice be issued, then my lord, council will come and it is a.
No,
contempt.
how can Vijay Chaudhary will receive notice? when
This
she is not in service?
respondent number 1 is no more there. Then this is-
It's not a question of my objection. I just pointing
You
out
have to
the.
file an impletement application.
My lord, then other, my lord, it is no notice has been, other may, my lord.
Who's the main respondent?
My lord, these 2, 3, 4 are that, my lord, because direction is my lord to the respondent authority. Page 15, my lord.
Obviously, so respondent 1 has to take steps first.
I'll take first steps, my lord.
Respondent 1 has to take steps.
My lord, implemented.
After that, it will go to finance. After that, it will go to all these departments. So unless respondent number 1, the name is changed. Why don't you understand all this problem?
My lord, my
Why
lord,
don't you understand this
my
simple
lord, I have to
issue?
take instruction on that.
No, you furnish the name of the incumbent.
Narayan Kaur is a secretary school education for both secondary and
yesterday
elementary.
Narayan Kaur IAS, if I'm not wrong.
Yes.
Secretary School Education.
My-
For both elementary and secondary, both department.
You make that,
I implemented the through IML.
you want to withdraw and file afresh also, that is also possible, or you can file
IF for implement, my lord. File IF for implement.
without issuing notice.
Case is not yet admitted, how can you file it?
My lord.
You withdraw with liberty to file afresh. with the-
Afresh, my lord, I'm showing the, with the limitation is there, my lord. I'm just taking it. Yes, my lord, I can. 2020.
Mister?
Yes, now.
Yes, not Land Council for petitioner press for withdrawal of this contempt petition with liberty to file afresh.
Okay.
Praise allowed. Contempt petition is closed on withdrawal with liberty as well.
My lord, obliged.
55.
Lordship, this item has been wrongly listed in for orders. It should have come for motion, Lordship. Lordship may fix the matter in the next week motion item. Or Lordship may please to issue.
Notice has to go, isn't it?
Yes, sir.
Then why do you want it to come up some other day?
Lordship may issue not
UMS,
A.N. Hussain on behalf of S1.
where's the order?
The order annexure A page 12. The relevant part will be in page 15. Second from the
Heard so and so, Land Council for the petition, issue notice. Petitioner takes steps for service of notice on the sole respondent by registered post CD within 1 week. Lists up to 6 weeks.
57 of supplementary list ordered.
Well, this is a contempt case of 2018, and the last update is here, my lord. Actually, there are three separate cases. There were three separate cases, out of which two have not filed any contempt case. They have been regularized. The benefit has been given to them, but not to me. And the director
have gone or not?
the director has appeared, my lord, and filed his reply. But the commissioner and secretary, earlier commissioner and secretary, recently I have been informed that he has been transferred. Then
Yes.
I have to complete respondent number 1.
Then you file an IA.
But the respondent number 3, director, he appeared in the year 2019, filed reply, but till date nothing has been done by him also. And specific direction was him again. And 3 cases jointly
Who's the
passed
respondent number 3?
director.
When was this filed? 2018?
Yes.
Contempt matter.
Yes, in there the affidavit is also there, my lord.
Mr. Chisti, just have a look at the course title. See if all the officers are there.
And one is not there, retired. Nirda Devi presently holding the post of Director of State
He is still here.
SCRT.
How
Nirda
about
Devi,
Commissioner Secretary Finance?
Finance,
Respondent number 2 is not there, but
No, 2 is also not. there.
not there.
two is not.
Then
And 4 is also
Main
not there.
direction was against 1 and 3.
why did you implement all of this?
My lord, because in the repeat, my lord, approval is needed, finance, but there before that, regularization order has to be passed by 1 and 3. That is to be
Yes, heard Mr.
DK Nath.
Not learned counsel for the petitioner prays for 3 weeks' time to enable him to file an application for implement of necessary parties. Praise a lot, at least up to the summer vacation.
But in the meantime, my lord, my friend may get the instruction from the
I'm not.
team.
I'm not.
Earlier, A Deka was
A
there,
Deka
I think, against 3.
We'll see.
অবনী এবং এরকম